I was praying for leave to do the outside motion and move it to go. So this is not against an order of the Public Premises Act. But as usual, stay has been granted. But as per the estate officer, more than about 60 crores is my bill.
What is the extreme urgency you have to move tomorrow?
The public property, this
Shit.
manor hotel.
That's not that urgent that it is to be moved tomorrow. File it, it will appear on the day you mention in the presentation form.
Could it be day after?
The day which you mention in the presentation form, I think 48 hours notice is only required. Gap is only required. The day which you mention in the presentation form for listing on that date, in my code, that is being listed.
Yes.
Allowed, kindly allowed to mention for upgradation, the monthly
Upgradation, please hand over the slip, provided you have issued notice to the other side, mentioning for upgradation. Please don't hand over the slips unless you have notified the other side for upgradation.
My lord, this is the motion stage, my lord.
If there is no caveat, you can mention,
Yes.
but if there is a
There
caveat,
is no caveat, my lord.
all right. If you
Monday, not 30.
please hand over the slip, mentioning the urgency.
Inclusion, madam. Inclusion in the list, madam. List and motion.
Please wait, upgradation, please hand over the slip, provided you have served notice upon the other side. Upgradation, please wait. I've said upgradation, please.
My lord,
Upgradation, please hand over the slip.
my lord, I had already issued notice. My lord, the notice is with my clerk. Lord, may I hand it over during the lunch period to your court officer? Dada.
If there is no caveat, you can hand over. If there is caveat, if the
My lord,
upgrade-
may I have your lordship's motion for upgradation up the next day.
Send over the
My lord.
mentioning the urgency.
My lord, this is for application for extension of interim order.
Extension of interim order. Please
After-
hand over, please wait. Extension of interim order, please hand over the slip.
Extension of interim.
Extension window.
My lord, I have two matters.
It will appear under the heading application. If you have filed application, please. mention
I have
that
two
it will
matters,
appear
my
under
lord.
heading application.
My lord, I have two matters. One is, my lord, for restoration.
Sir, please wait. Applications, please hand over the slip.
And my lord,
Applications, please hand over the slip.
my lord, my another matter is, my lord.
Sir, please wait. Applications, please hand over the slip.
Sorry.
Motions inclusion, please hand over the slip, provided you have issued notice upon the other side.
First date. First.
Your lordship.
Please hand over the slip for inclusion of motions.
My lord, long pending, 90 years old. And on earlier two occasions, I got, my
Please
lord.
mention the urgency, write the urgency. Most of you are handing over slips without mentioning the urgency.
Your lordship.
Please hand over the slip.
Your lordship, may I be permitted for
Please hand over the slip.
lordship? Your lordship, may I be permitted for upgradation?
Please hand over the slip mentioning the urgency, provided you have issued notice to the other side.
Your lordship, the item number is 71 in today's list.
Madam, if please serve notice upon the other side, then hand over. Have you served notice?
Yes, your lordship.
Where is the notice?
We have already served. Oh,
Notice for upgradation. Have you served notice?
lordship.
Please return kore din. If you have not served notice for upgradation, please don't mention.
My lord, may I have my lord sign my lord under extreme compulsion, my lord, may I may I be permitted from, mentioning one matter of contested application, a demolition order has been stayed. My lord, I am a flat owner.
Contested application is very difficult.
Lordship, I would not have troubled your lordship, my lord, under my flat, the unauthorized structure.
Madam,
that
please
is-
do
Any
motions. After finishing the motions, I will take. That it's not possible.
May I have my lords kindly to mention, lordship, it appeared for the first time, lordship, it was dismissed for default. I filed the application.
Applications are paid, hand over the slip. Yes, motions for inclusion, please hand over the slip.
Your Lordship, one submission.
Any motions for inclusion, please hand over the slip.
Lordship, one submission.
May I have? Lordship, may I have?
Yes, madam, I have said hand over the slip for extension. Application, initially I have said extension, thereafter application.
May I have your lordship's leave to mention? My lord, it is 161 of today's
You
list.
do what, madam?
My lord, kindly, if my lord kindly.
Application.
No. This the petitioner does not want to proceed with the instant matter. Kindly fixes this tomorrow for withdrawal.
ওইটা non-prosecution বলে, have you mentioned for non-prosecution?
Yes.
Non-prosecution to be mentioned tomorrow কালকে করে দিন.
Your Lordship, one submission.
Matter, Baripur court matter, if my lord has some difficulty.
Madam, she is standing in your front and you are coming from there. Please maintain the decorum.
Expired on 30 June.
I have said hand over the slip for extension of it. You did not mention for that.
Your Lordship, one submission. Your Lordship, this is for inclusion in the list, Your Lordship, and for taking up the matter. Your Lordship, the opposite side had a stay order till.
What do you want?
Your Lordship, we would like for the matter to be taken up as soon as possible. Your
Please
Lordship.
hand over the slip mentioning the urgency.
Urgency is there, Your Lordship.
My lord, with your lordship's kind leave.
Contested application.
Contested application, please mention for inclusion.
There is returnable date was 9th.
Yes, yes.
My lord, it's not come in the.
Contested application, not now.
With your lord.
There, warrant of issue was issued by the court below, my lord. The returnable date before the court below, my lord, 3rd July, my lord.
Contested application, not now.
With your lordship's kind leave.
Finally,
Well,
Not possible, yes.
Your number 646 of 2025 yesterday I had proposed for your lordship, and your lordship had given me liberty to approach for your lordship today. The issue is
What
that
do you want?
my lord, the next date before learned security.
What do you want? Upgradation, please hand over the slip mentioning the
A
urgency.
date kindly be fixed before 6th of July, because on 6th of July is the final date for hearing.
Sir, can you not indicate that in the mentioning slip?
Yes, my lord. Yes, my lord.
And can you not take the trouble of coming
my lord.
tomorrow to ascertain what is the
No, my
fate of your application?
No, my lord.
Lordship, may I permit to mention, Lordship?
Every day that is being indicated, dates are being fixed. You do not take the trouble to ascertain.
Lordship, may I permit?
And you are saying, yes, only it has been upgraded today.
Lordship, may I permit to mention, Lordship? The correction of your Lordship order, Lordship.
Yes, hand over the slip for. দেখুন তো
অর্ডারটাও দিয়ে দিয়েছি, হ্যাঁ দাদা, অর্ডারটাও দিয়ে দিয়েছি। Lordship, may I be permitted to mention?
for
May I permit to mention?
yes, please hand over the slip for release.
Lordship, may I be permitted to mention a matter for correction, your lordship?
Lordship, may I permit?
What is the urgency?
অর্ডারটা দিয়ে দিন।
I cannot hear you. What is the extreme urgency? You file it in the department, it will appear.
Lordship, may I permit to mention?
Are you filing with the certified copy or without the certified copy? With the certified, file it in the department, give the date, it will appear on that date.
And may I?
Lordship, may I permit to mention? Lordship?
To be mentioned again.
Lordship, may I? Lordship, may I permit to mention? Lordship? To mention, matter was taken up, Lordship, 19 May of 20. Lordship, matter was taken up, Lordship, 19 May of 25. It was directed to applicant, Lordship, 12th of June of 25. Today's item number 92, Lordship. Update the
Please hand over the slip.
Lordship,
given.
may I be
I
permitted
have
to
mentioned,
mention?
madam, then.
Lordship,
If you individually want to mention, yes, mention. I will hear all of you. Yes, yes, please start. I have no difficulty in hearing all of you. In order to save time, I'm asking you to hand over the slip. I will look into that. If you want to individually mention, no problem. I will hear all of you. What do you want? Hand over the slip. Who is appearing for the Paniati Municipality? Have you informed him? Item number? Item number 82 to 2 p.m. Which was taken up yesterday. Item number 82, 2 p.m.
Lordship, I have same matter, my lord, on 11, my lord, Lordship inclined to fix the matter on 2 p.m. My lord,
Please hand over the slip.
Lordship, upon notice, my lord, Lordship, that day instruct me, upon notice you mention the matter, then I can fix the
Hand
matter.
over the
My lord, 2 p.m, my lord, kindly, if possible, my lord.
Please hand over the slip.
My
I will
lord,
consider that.
on 23rd May, my lord, what had two matters CO arising from the same order and thereafter reserved that for order or judgment.
Yes.
My lord, pursuant to that, we have filed one application under Order 7, Rule 11, stating therein that this particular suit is not maintainable against us and that has been made returnable on 2nd July. Just mentioning that that has been reserved for order on 23rd of May.
That I will see.
Lordship, may I be permitted to mention a matter?
Yes.
Contested application.
Contest application, please don't mention.
Last date has
May I
been
permitted
given in
to
the court
mention a
today,
matter?
3rd July. That was the last date fixed by the.
Sir, Lordship, may I permitted to mention a matter? The opposite party had obtained an interim stay order in the year 2018. It is 2025. Only the extension of interim order has been done.
2018.
Yes, in the trial court. In the trial court, but the application has been filed in the year 2024 for expeditious disposal.
Yes.
The matter has not been done anything, no substantial progress has been taken place. It is running in the item number 350. Kindly upgrade the matter.
Hand over the slip.
I will, Lordship's kindly to mention a matter, Your Lordship. This has been fixed for passing final judgment this Monday. Your Lordship will kindly hear out the matter this week anytime.
Hand over the slip.
Your Lordship, 30th of the June is fixed.
Please indicate that.
I have mentioned that. I have mentioned.
Please
May I
indicate
seek-
that.
Well, may I seek your lordship's leave? But item number 80, my lord, your lord, the matter was taken up yesterday at the behest of the caveator, my lord, an adjournment was sought for. My lord, this relates to the transfer of the case in the Alipur matter, my lord, when Mr. Mukherjee, Tanmay Mukherjee is leading me, my lord. But I'm seeking, my lord, any time today or tomorrow, my lord, if your lordship, because it was,
Hand over the slip.
well, my lord,
Mentioning the urgency.
Serial number 71. It is a
71.
71. Expeditious disposal.
Hand over the slip.
My lord, may I be permitted to mention one matter, my lord? My lord, for expeditious disposal of the urgency. My lord, already the NCLT pleadings has been completed, but till now the matter has not been disposed of. And it is in the monthly list running, item number 547, my lord.
Hand over the slip.
Grateful, lordship.
My lord's kind leave to
Virtually without a
my lord's kind leave to mention, my lord. My civil divisional application, my lord, sentence around, my lord, the order challenged, my lord, in relation to the Guardians and Wards Act, my lord. I being the biological father, my lord, the in-laws have taken forcefully the daughter, my lord, to their place, my lord. I have challenged the impugn order passed by the learned Barashat court. My lord had heard it directed for affidavit of service in the month of February, my lord. What I am suffering, my lord, today, the order passed by the Barashat court directed, my lord, to meet my daughter, minor daughter, once in a month on Sunday. Now that's the order I have challenged, my lord, seeking only for modification of the order, my lord. I have, my lord, handed over the slip, my lord, kindly, my lord, for upgradation, my lord. Great.
Yes.
Lord, the petitioner is virtual. This matter was taken up by your lordship, but due to paucity of time, the matter could not be concluded. It only started in motion stage, my lord. My lord, what has happened? I am without an injunction order, without a suit. In the partition suit has been referred to the arbitration, my lord. This matter was once heard at 4:15, my lord. There was no time, my lord. Could not be taken up. But it's running as item number 87 of today's list, my lord.
Hand over the slip. Yes.
May I be permitted to mention a matter, not under the heading of to be mentioned? My application for correction of degree in the trial court was rejected. Due to
Why
the
to be
fact,
mentioned? It has been hard in motion. It has to be hard. Why to be mentioned?
Lord, this is a simple issue, my lord. The
All matters are simple.
array of the party was rejected.
All matters are
In the
simple.
degree under
To be
150.
mentioned are not meant for that.
Can it be upgraded? Lordship, can it be upgraded?
Mention the urgency, submit the list.
My lord, item number 321 of today's list, 8th of July is the date fixed in the lower court for awaiting order of the honorable court. Otherwise, DW will start, your lordship.
Hand over the slip mentioning the urgency.
Item number 256, my lord, I got the order of possession of the property. Thereafter, the opposite party went for the appeal, but they did not contest. My lord, thereafter, I filed the execution. My lord, it is, but execution proceeding is not happening, my lord. From 2018, I'm stuck. My lord, this matter I have repeatedly mentioned for about 8 months, my lord. It is in the list. Kindly, my lord, it's a very short matter, my lord. Kindly hear me out.
Have you indicated the urgency?
Yes, my lord, execution proceeding is from 2018 and the matter is pending for 8 months, my lord.
Hand over
Very
the
short matter, my lord.
all matters are short, madam.
So this will not,
For you, not for the court. Court takes time to understand the matters.
my lord, kindly this be present in the.
My lord, another matter of the combined monthly list, item number 555. My lord, the learned court has closed my PW as because there is no stay order from the Honorable High Court and DW evidence has started. My lord, kindly fix any date.
Hand over the slip, yes.
Great.
Item number 995 of combined list of this month. You have to kindly release.
995, why?
One of that 4 times I matter was mentioned, but that has not been given us.
Mention that in the mentioning slip.
Yes,
Yes, indicate that hand over the slip.
Last witness I mentioned, my lord, that slip has not been.
Today, you please hand over the slip, praying for releasing.
My lord, may I have a lordship kindly to mention a matter not appearing in lordship list, CO number 409 for 2024.
Not in the list.
Not my lord. My lord, it was due to appear on 27 January 2025. My lord, the matter
It is in the list or it is not in the list?
not in the list, my lord.
What do you want, inclusion?
Yes, my lord.
Hand over the slip.
Lordship, petition for expeditious disposal. In the year
I'm obliged, my lord.
2022, I had filed on application under Order 22 Rule 10. It still has not been heard, Lordship. And this is 2025, Lordship. I am not being able to join as a plaintiff. I am the subsequent owner of the suit premises, Lordship. Expeditious disposal application I had filed in 2024 is still in the motion stage, Lordship.
Hand over
I
the
have
slip.
handed over.
My lord, may I be permitted to mention?
Hand over the slip, sir.
I have handed over, Lordship, earlier.
My lord, may I be permitted to mention that? My lord, this is regarding discarding of evidence. Discarding of evidence. As the matter was going ex parte, my lord. And my lord, the next date in lower court is 27 June. And my lord, I have given the certified copy where last chance is given to us if a stay order is not given, my lord.
Hand over the slip.
Lord, may I permitted to mention, Lord? Lord, on the last occasion on the prayer of the plaintiff, it was adjourned, my lord. Now it is out of list, my lord. It's the motion matter, my lord. I'm praying for inclusion.
Hand over the slip.
Lord, one application for restoration, my lord. Next date is fixed on the 2nd week of July, my lord.
When it was dismissed?
My lord, 2nd May, within 5 days I filed an application. I was struck. Before my lord,
Someone should have been here. Hand over the slip.
2nd week of July.
Will appear in the month list.
আমার যে আমার আলিপুর কোর্টে একটা ডেট মানে ওখানে একটা কেস আছে সেটা ট্রান্সফারের জন্য এখানে অ্যাপ্লিকেশনস করছি বিগত 6 মাস ধরে অ্যাপ্লিকেশনস করে যাচ্ছি কোনোভাবে হচ্ছে না আমি কালকে যিনি এই অপোজিট পার্টির যে লয়ার ছিলেন তাকে মেল করেছি কিন্তু তিনি বলছেন উনি এখন এই ম্যাটারে নেই কিন্তু উনি আরেকজন লয়ারের নাম্বার দিলেন যিনি এই ম্যাটারে আছেন তো তাকে মেল করেছি তার প্রিন্ট আউট দিয়ে 666 আইটেম নাম্বার রয়েছে আমাকে ওখান থেকে আলিপুর কোর্ট থেকে বারবার বলছে যে আপনি বারবার এরকম করে ডেট গুলোকে নষ্ট করছেন এরকম করে অপোজিট পার্টিকে হ্যারেস করছে কিন্তু আমি হ্যারেস করছি না আমি এখানে বারবার দিচ্ছি অ্যাপ্লিকেশন কোনোভাবে কনসিডার হচ্ছে না কোনোভাবে কিছু হচ্ছে না আমাকে খালি ট্রান্সফারে আমি অলরেডি ট্রান্সফারের একটা স্টে পেয়েছিলাম সেপ্টেম্বরে তারপর থেকে কোনোভাবে এটা হচ্ছে না যশাল একটুখানি আমাকে একটুখানি ট্রান্সফারটা আমার একটু করে দিন হাওড়ার আমি ট্রান্সফার
দেখুন তো এটা সেকশন 24 পিটিশন সেকশন 24 দেখে নিন তো এটা টু বি মেনশনে দিয়ে দিন কালকে দেখে নিন সেকশন 24 হলে টু বি মেনশন
My lord, item number 356 application matter is review application. While running the list, finally fixed for tomorrow to create.
Hand over the slip.
My lord, praying for inclusion of a contempt application.
Contempt. Hand over the slip.
Upgradation 856 monthly list.
856 monthly list for upgradation to section 24.
You have indicated the urgency. Hand over this. Any other mentioning? I thought that there will be some other mentioning. Yes, call the list.
Item number 2. I have appealed for petition. But there is type of application.
Yes, item number 2. Why to be mentioned?
Suit is actually pending Millard before the Millard Civil Judge Senior Division.
So why it is appearing under the heading to be mentioned?
Correction of order.
Correction of the order. Correction of which order? 6th of May. What is the correction you want?
Correction will be Millard.
Please use the microphone, sir. Please use the microphone.
Correction will be Millard. Direction will be upon Millard Civil Judge Senior Division. Millard Srirampur Hooghly. Millard here Millard mention Millard second court. Millard second court will not be Millard.
What is the court?
Millard.
Sir, please come to your cost title. Please come to your cost title. You have mentioned second court.
Millard actually it is file Millard second court.
You have mentioned in the cost title as second court.
And Millard thereafter Millard super transfer to Millard Srirampur court. Millard there is no second court Millard. And Millard.
In the cost title you have said second court.
Millard.
It's your mistake.
Mistake Millard.
The learned
And for the opposite party.
Yes.
On the last occasion, we have already handed over the brief notes of argument before your lordship.
Yes, you are headed up. Where is the
Mr. Siddhartha Banerjee is appearing. He is engaged in another court. I am filing my written notes of argument.
written notes of argument filed by the learned advocate for the petitioner?
Item number 4, has been listed as to be mentioned at my instance, this is section 24.
Section 24 Civil Procedure Code.
Yes.
For want of determination, let the matter go out of the list. Yes. Next.
This is my application for extension of interim order.
Call the next matter.
Item number 5. My lord, may kindly seize the last order of 17th of December 2024. The interim order was extended till end of June 2025 with a direction to serve the copy of the said order. But I have served the copy of the said order upon the opposite parties. But they are not appearing in the earlier occasion also. A copy of the civil revision application was filed. They did not appear.
What is the order impugned?
But this is an application. The plaintiff is the petitioner before your lordship in a suit for declaration and injunction by assailing the order number 11 dated 9th of January 2024, whereby my lord, along with the injunction application, the plaintiff filed an application under Order 13 Rule 7 for local inspection and an application under 151 so that the application for local inspection may be held prior to the hearing of the injunction application and the material may be placed before the court concerned. But that has been rejected on the ground citing Order 39 Rule 3 capital A.
No, it was fixed for hearing on 13th of February 2024. What happened after that?
We obtained an order of stay. Stay is operating. Kindly see the order. First order passed by the coordinate bench on 7th of May 2024. Matter was admitted and the direction was stay till 30th September 2024. Thereafter, it was extended by the coordinate bench.
I'm extending the interim order.
I am for the petitioner, my lord. This is for extension. Last occasion on 25th March 2025, lordship pleased to extend the order till end of one prayer, my lord. Due to communication gap, my lord, we could not file the opposition, my lord. Kindly 2 weeks time be granted, my lord.
You want to file opposition?
Yes, lordship was granted. It was already directed, my lord.
On the prayer of Mr. Nag, learned advocate, appearing for the opposite party.
Yes, your lordship. I am grateful, my lord.
Check.
Lordship, I'm led by Mr. Bose. I'm asking for passover for just 2 minutes. He's on his way, just 2 minutes.
Passover next.
Number 8. I'm for the petition.
Yes.
Pursuant to my lord's last direction, my lord, I have served the copy of the application.
Nobody is appearing.
No, my lord, the decree holder, my lord, the postal envelope, my lord, with regard to the endorsement, both the decree holder, my lord, it has been served.
When have you served?
My lord,
March. Nobody has entered appearance.
CIS system also shows, my lord, nowadays, my lord, if someone filed vakalatnama, we can see
It is indicated.
No indication is there. I have checked up yesterday night also.
All right. Every service filed in court today is taken on record.
The interim order was that was passed on.
Kindly be refer to mediation center. There is a chance of my lord.
First suit for
There is a chance of my lord.
No, I know.
My lord,
The first suit was
He is not agreeing to that.
Yes.
What can be done?
actually, my lord,
Suit was this is what
we
it
are
was.
deciding
That
separate-
was restored. First matrimonial suit of 2011 that was not dismissed.
What is the order impugned?
It is the mandatory point. I filed an application. Is the second suit has been for the same cause of action.
No,
Suit for divorce.
That
On
is
my submission before losses other day, my lord.
dismissed
Whether
in the year 2000.
without restoring that
Then, my lord,
this
a
for divorce.
compromise was
Right, I'm extending the interim order. I'm fixing it.
Yes.
Under the contested
My lord,
application.
my humble submission is this, my lord. They never lived together as husband and wife. Marriage
Sir,
was
he is
been
not agreeing to go to the mediation. How can we force him to go to the mediation?
The matter will be compromised, my lord. There is a chance of my lord
He
compromise.
does not want compromise. Can you force compromise upon him?
No, that's not my lord. Yes.
Yes.
You have the petition. Right, order dated 4th March, you have passed an interim order and we have already served the application along with
Who is for the opposite party? Every service filed in court today is taken on record. You are
Item number 11.
Yes.
I am playing a short passover. Led by Mr. Siddhartha Banerjee. Well, he is
Passover next.
Item number 12.
This is that matter of mediation.
No, no, my lord, the yesterday matter was heard by your lordship, just they will inform the how many witnesses they were, they will examine.
Yes.
My lord, yeah,
In a suit for specific performance of contract, the subsequent incorporation by way of amendment, the plea of adverse possession.
They are not appearing. Your suit is being stayed.
It's not my suit, my lord, their suit. I'm the defendant.
Opposite parties.
They said they have given me money and there is an agreement for purchase of my property.
You are the plaintiff.
Defendant petition, my lord, item number 12. 1008.
Item number 12, এটা কি দিয়েছেন? 13 এর ফাইল দিয়েছেন. That is why I find that the plaintiff is the petitioner. এই এটা কারা রেফারেন্স? কোনটা রেফারেন্স সার্ভিস? ওইটার? Every service filed in court today is taken on record.
Deposited in terms of first part of section 7.1. Admitted rent.
Admitted rent is 7.2.
Admitted
There is
rent
a
is 7.2.
Mr. Banerjee, there is a
Admitted rent is 7.2.
go under 70.
Under 7.2. If there is no this 7.1, question will apply. Now, Lord 7.1, Lord first part, second part. Now, Lord first part he is to comply. Or which cannot be extended.
First part is immediately after appearance, or which month is the second part?
For which it cannot be extended. The landlord court has extended.
Now, Mr. Banerjee, have you seen the recent decision of the Honorable Supreme Court? You have seen you might be aware of the judgment in the case of Debashish Pal.
Debashish Pal, yes.
Debashish Pal, paragraph 17, it says that though you are appearing for the other side,
yes.
Though the proviso is appearing after
that is why, my lord, another.
So, but,
yes.
So
again, paragraph 17.
In a subsequent,
the opportunity will be given for 2 months.
Yes.
That is why
that issue is pending consideration in another matter.
In another matter, judgment has not been delivered.
Hearing has been concluded.
Judgment has not been delivered.
So,
Lordship, kindly extend the interim order, fix it. Lord, this is
you will be benefited. You are the tenant.
Also,
Because that's the
that's
the window which might come to the tenants.
That is the right, my lord. Because in paragraph 17, Lord, in paragraph 17, Lord, I could not follow because 7.2, my lord, determination that is proviso.
Mr. Banerjee,
But not 7.1.
Mr. Banerjee, after all, the law laid down now. Law declared. We have to follow.
That is the reason, my lord. Another bench, my lord, heard it. No judgment has been delivered.
So
till date, an amicus curiae has been appointed. Amicus curiae has been appointed. Hearing concluded.
Only the judgment has been reserved.
Lord, in April 2025.
Let's wait for that. Some window, if it comes.
Yes, some window is there.
If it comes, we do not know till now. Asun.
Kunta.
1064.
Yes, you are appealing for all the opposite parties.
কপি দিয়ে দিই আপনি একটা চিঠি দিয়ে দিন না তাহলে ভালো হয় আমাদের
আমার 1064.
Yes, what happened?
সব
He has not got copies.
I did not
Yes.
receive the entire copy of
Banerjee, please ask your junior. to
I
explain.
told him তুমি নিয়ে নাও আমার।
Mr. Banerjee, learned advocate, appealing for the petition.
Item number 14.
14 my lord, same identical matter.
Same,
Affidavit
same order. Order date is same.
Service is filed.
Yes.
26th of March, same order.
Grateful.
Yes, next.
No.
Item number 15.
My lord,
Well, 15, 16 and 17
you are appealing for the
for
opposite
the
party.
extension of interim order, Millard.
The matter is fixed on
Millard
10th
15,
July
16 and
before the
17
commercial
appear
court.
for the petitioner. Millard is appearing for the Millard extension of interim order, Millard 15, 16 and 17.
It is appearing under the heading fixed matters.
Yes, my lord.
The interim order
Yes, it
passed on.
Item number 18.
18 my lord.
একটা জিনিস দেখে নেবেন তো এগুলো কি
This is that occupational charge.
Yes. Occupational charges in a proceeding under section 6 of the West Bengal Premises Tenancy Act
My lord.
during the pendency of the suit.
My
Yes.
my
Seven. এটা কেন আছে?
Well, I'll just trouble your lordship with only one judgment.
You said 3 judgments, Mr.
No,
Bose.
but one right now, my lord, one is sufficient. Because the others are on different facts. So,
So one is pattern facts.
well, I would say applicable. 2024 volume 8 Supreme Court cases page 668. 668.
Yes, that judgment you have handed up. That was there yesterday. You took time to cite few other judgments.
No, my lord, if your lordship will see, the answer is in this judgment itself.
Yes.
My lord, if your lordship kindly, if I may just trouble your lordship with the facts once.
Yes.
My lord, the issue was, my lord, the single bench judgment is also with us. My lord, it was a suit under the Transfer of Property Act before the Learned City Civil Court at Calcutta. Defendant took the point that this suit is not maintainable because it is governed, the tenancy is governed under the West Bengal Premises Tenancy Act. Order 7, Rule 11 application filed. My lord, eventually, my lord, when the matter came up before this honorable court, my lord,
You are
it's civil division.
but you are ready with this matter?
Yes, Lord.
You are ready?
Yes, Your Lordship. I filed one CAN application for modification of the interim order because, Your Lordship.
Are you ready with the main matter? Not on the extension. I'm hearing the main matter. Because Mr. Bose is ready.
I will try my level best, Your Lordship.
If you are ready,
Yes, Your Lordship.
yes.
Ready. My lord.
Yes.
So, my lord, when the civil revisional application, my lord, the order of the, my lord, the trial court was upheld, and it was held that the suit is not maintainable. Under the Transfer of Property Act, it ought to have been rejected. That went up before the Honorable Supreme Court. So that means there is no decree. The tenant claims
Yes, rejection of plaint is a deemed decree.
decree.
Not a deemed decree.
What I meant is there is no decree against the defendant.
Section 2, regular appeal lies. It's a decree, Mr. Bose.
What I meant is there is no decree against the defendant. There is no decree of eviction against the defendant.
May not be.
Yeah,
but
that's what I said. Oh, yes. Well, I stand corrected. Well, what I meant is, well, for occupational charges, well, that aspect. So what I meant is there was no, in this matter,
no decree of eviction.
Eviction against the defendant. So no proceeding against the defendant. No, but here there is a suit which is pending for 3 decades.
No. Let us.
Yes. Now,
this case.
That's what I'm saying. Well, under this perspective and these facts, the Supreme Court has passed this order. Well,
after the plaint was rejected, what happened?
Nothing happened. The landlord went before the Honorable Supreme Court.
There was no appeal.
No revision. 227 revision, especially petition.
Why 227 plaint rejected? Why 227?
I don't know, but there's a 227 which was filed.
How can it be?
It was rejected in the civil division stage. Allow me to correct that one.
So plaint rejected in civil division?
Possibly. Allowing the matter at the rest, the respondent tenant pursued the subject matter. Oh, this went back and came. There was a remand from the Supreme Court. There were 2 rounds.
Yes.
My lord, I stand corrected. My lord, initially, if your lordship kindly looks at paragraph 2, the original suit was before the City Civil Court. Then para 2 says, impugning the judgment of the single.
Mr. Bose, was it a case of expiry of lease?
No, breach, termination, 111G. So now, my lord, initially there was a special leave petition. The Supreme Court remanded the matter back to be decided on the preliminary issue. So that preliminary issue was decided, that your lordship will find my lord, kindly take paragraph 4. Rejection of plaint on the ground of jurisdiction on the premises, alleging particular possession thereof sought to be such and such, the claim bad in law such and such. Then, my lord, the same came to be rejected by the court concerned by such and such. So the trial court, my lord, rejected it. That's why it was civil revision. Then, my lord, kindly take paragraph 5. Allowing the matter not to rest there, the respondent tenant pursued the matter. High Court in civil revision under 227, such and such upheld the dismissal of order 7. Eventually, this matter, such and such directed the remand. So Supreme Court remanded the matter back. Thereafter, when taking into consideration, this is the set out portion of the Supreme Court. The trial court framed the issues. Trial court in all 4 suits answered the issues in favor of the plaintiff. primarily on the ground that since the tenant subject matter of the suit was created in such and such, this was what the trial court said. Then the matter came back. Then my lord, para 8. So the tenant succeeded in the High Court. Para 8.
Yes.
Against which the special leave petition before the Supreme Court. So my lord, when the matter was before the Supreme Court,
yes,
there was nothing against the tenant. Now, my lord, your lordship will kindly take. During the course of hearing, paragraph 10, on 15th of February 2024, petitioner applicant landlord had offered time to the tenants to vacate. Certain suggestions of amicable resolve the dispute for all times to come were exchanged, and as such the matters were adjourned. We are now informed that the petitioner landlord's offer of giving time to the tenant to hand over vacant possession stands rejected. Thus, the landlord insisted on the disposal of the application seeking the tenant to pay the rent at the market rate for the list to have been determined at the institution of the plaintiff. Now, this interlocutory application was being considered. The interlocutory application bearing the above particular has been taken as a primary application for the sake of facts. It is noted that similar applications seeking similar prayer have been filed in other special leave petition which shall be disposed of in accordance with this order. We notice that these applications in issue have been pending for almost 3 years. Then, my lord, the applicant, petitioner, the special leave petition seeks direction for payment of, my lord, your lordship will kindly make a note of this, monthly occupational charges.
Yes.
Following the prevalent market rate. This was the prayer. My lord, they wanted 41 rupees per square feet, such and such. Then, my lord, para 14, kindly take certain facts are required to be taken note of. The property in question is situated at Dalhousie area, which has been termed as a commercial hub in Kolkata. Lease rent, the lease agreement inter se was entered into 91, executed by the predecessor. It is alleged that the respondent has been in default of payment of rent and in default of payment of share of municipal tax. Then, para 15, on account of non-payment of rent, the lease was forfeited. However, the respondent was neither delivered possession nor paid the rent. Petitioner submitted report of the independent valuer. The assessment of the rental made by the valuer, it is submitted, is fair and reasonable. Then, this is the tenant submission at para 16. Tenant submission is at para 16.
Yes.
It is submitted on behalf of the respondent that since no court has declared the end of the landlord-tenant relationship, the petitioner applicant asking the respondent to pay occupational charges as opposed to contractual rent would amount to rewriting the tenancy agreement. Further, it is argued that occupation charges are only payable after the lease is validly determined or after the decree of eviction. Since both these eventualities are yet to occur, no question of such payment arises.
It is. You can straight away come to paragraph 28.
My lord.
Because that's the distinction made from
what I wanted to show once is, my lord, if your lordship will take para 16, the chart that the tenant had given, he was paying.
No, that will come later. Chart at what rate? First is whether tenant is liable to pay during the pendency of the suit at a rate higher than the last rate of rent paid. So please come to 28. So add to that, starting from Attaram, Supermax, everything was considered.
Correct.
Please come to paragraph 28.
My lord.
Please start placing from paragraph 28 onwards.
My lord. Then if your lordship
2 or 3 paragraphs after that, so
my
the
lord.
issue.
My
Yes.
lord. My lord. Your lordship will also make a note that para 27 takes into consideration Martin Harris, 2022.
Yes.
Then, a perusal of the judgments extracted above, as also other cases where Atmaram, one common factor can be observed. Decree of eviction stands past, and the same having been stayed gives rise to the question of payment of main profit. As observed above, the respondent contends that since in the present case no decree for eviction is passed,
that was the distinction sought to be made. Now kindly come to paragraph 29.
While the aforestated position is generally accepted, it is also within the bounds of law that a tenant who once entered the property in question lawfully continues in possession after his right to do so stands extinguished, is liable to compensate the landlord
for such time period after the right of occupancy expires. In this regard, we may refer to Indian Oil versus Sudera Realty. Now, my lord, kindly also take Sudera Realty one portion.
Yes.
It says the tenant continuing in possession after expiry of the lease may be treated as a tenant at sufferance, which status is a shade higher than that of a mere trespasser.
What is the status of a premises tenant who has been served with a notice under section 6(4)?
Tenant at sufferance.
Is it so? Is it so?
Well, interpretation of
or is otherwise. There are decisions on this. Yes, now kindly come to paragraph 30.
It is to be noted that the court at Sudera observed that mean profits become payable on continuation of possession after expiry of lease. In our considered view, the effect of the words determination, expiry, forfeiture, and termination would subject to the facts applicable be similar. That is, when any one of these words are applied to a lease, henceforth the rights of the lessee stroke tenant stands extinguished or in certain cases metamorphosed into weaker iteration of the former selves. Pausing here for a moment, I say that when I issued a
notice.
Yes.
So the basic distinction, Mr. Bose, with Aftaram and others, Aftaram and others is after a tenant suffers a decree for eviction, he comes up in appeal, wants a stay, so he has to pay occupation charges. Now, this distinction is in a case where there's been an expiry of lease or forfeit, anything. So the right to continue stands forfeited. Right to continue. That's the distinction. So proceeding under section 6 is initiated by issuance of a notice under section 6(4). Do you mean to contain that service of notice under section 6(4) means expiry of lease?
No, expiry. I said determination. Determination of the tenancy.
Please kindly come.
Determination of the tenancy.
Kindly come to the provisions of section 6(4). Show me where is the determination of.
Today, if your lordship will see,
yes,
based on the facts of this case,
Mr. Bose, show me because that has to be applied. Please show me.
I am saying
of lease or a tenancy.
I am saying that your lordship need not even apply that. This is the departure in this judgment. Here is a case, because here was a case that there was a determination of lease under 111G. Now suit filed. Suit failed. So as on the date when the matter was before the Supreme Court and when the Supreme Court directed payment of occupational charges at the current rate, payment, no deposit. Order was deposit, so my pair here is also deposit. Well, at that relevant point of time, my lord, there was not even a proceeding against the tenant. Whether for determination, so my respect submission before your lordship is a determination of lease under 111G, my lord, based on paragraph 30, my lord, should also be considered. My lord, the notice under 6(4) is pari materia notice under 111G. My lord, so far as situation for occupational charges during pendency of the proceeding is concerned.
Anything more?
No, my lord. Just one more paragraph.
Yes.
If your lordship will see para 30, it takes into consideration all the situations.
You can place
determination, expiry, forfeiture, termination.
Paragraph 30 for your satisfaction. You can place paragraph.
But I'll tell your lordship why. My lord, this is the departure. My lord, if your lordship will recollect, my lord, in the 90s, the price of potato was 2 rupees.
Mr.
Today, the price of potato is 20
rupees.
My lord, this is a situation, ground reality. This judgment is based on ground reality. You are enjoying a property paying 20 rupees. Today, if I let it out, I'll get 25,000 rupees.
You may be entitled to 1 crore per month. I'm not on that. First, show me your entitlement to claim occupation charges.
My lord, my entitlement is based on this judgment.
30.
My lord, 30 takes into consideration all the situations. Your lordship will see determination, expiry, forfeiture, termination.
Yes.
So 6(4) now, if your lordship comes to 6(4),
please, whether this comes within those expressions.
Yes, my lord.
6(4). Please show me.
George,
I have a cup.
Oh, my. I should have realized, sitting in civil division jurisdiction, but West Bengal Premises Tenancy Act is something which your lordship I'm sure considers on a every second matter. Notwithstanding anything in any other law for the time being in force, no suit for recovery of possession of any premises on any of the grounds as aforesaid, except on a ground mentioned in clause such and such, shall be instituted by the landlord unless he has given to the notice 1 month's notice expiring with a month of the tenancy.
What is the effect of a notice under section 6(4)? What is the effect? What does it want to mean to the to the
Well,
tenant?
my interpretation would be, I can understand where your lordship is taking.
These provisions, yes, 13(6), 6(4) has been well interpreted in very many judgments.
Yes, my lord, it says that these are the grounds under which I seek your eviction.
Of suit, nothing more.
No, my lord, also, my lord, kindly say.
Only a threat of suit, nothing more.
Well, my lord, today, if your lordship will also see, when I say that I am giving you a notice under 6(4), I'm giving you that the 30-day notice period is given. It is possible that a landlord may vacate based upon receipt of the notice.
Tenant may
vacate. Tenant, so he may not contest the proceeding. Yes. Possibility is there.
Yes, yes.
So my respectful submission before your lordship is that subsection 4, section.
Have you come across a single case of this nature, Mr. Bose?
Not in Calcutta, of course. May not be in a city of Calcutta.
West Bengal Premises Tenancy Act, it has to be within the state of West Bengal.
During the pendency of the suit.
During my tenure, I have not come across that side, this side, till date.
Well, why? Today, our courts
are the decision. Any more decision, Mr. Bose, you want to cite?
No, my lord. Then para 31.
Yes, paragraph 31.
Having considered the submissions made across the bar,
yes,
we note that the disputed nature of the lease deed, in other words, is continuation for forfeiture on account of non-payment, is heavily contested, and stemming therefrom, so is the nature of the payment to be made. We also note that the location of demised premises is in the heart of Kolkata, and if the submissions of the petitioner are to be believed, they have been deprived of rent for a considerable period of time. Taking a lock, stock and barrel view of the present dispute and averments and the documents placed before us, we may record a prima facie view that the respondent tenant has, for the reasons yet undemonstrated, been delaying the payment of rent on other dues payable to the petitioner applicant landlord. This denial of monetary benefit accruing from the property, when viewed in terms of the unchallenged market report forming part of the record, is undoubtedly substantial and as such subject to such exceptions. We pass this order for deposit of the amount claimed by the petitioner applicant to ensure complete justice inter se the parties. My lord, your lordship will also find.
What's the effect of this judgment? 141 or 142?
My lord, I would say, my lord, it is the 141 situation.
Last sentence clarifies that.
Last sentence of the judgment or that paragraph?
That paragraph itself.
Your lordship said to ensure complete justice inter se the parties. No, of course, my lord. I mean, inter se the parties wouldn't mean, my lord, that this principle cannot be applied.
That's 142.
It is, my lord, your lordship will see. My lord,
any other decision?
No, of course. This is the only decision.
Just let me hear the other side.
Yes, my lord. My respectful submission before your lordship is that, my lord, this suit has been pending for 3 decades.
Thank you for inviting me to paragraph 31. I have left out paragraph 31, but I am thanking you for inviting paragraph 31.
So, my lord, your lordship will see the, of course.
Yes, let me hear the other side. Yes.
Your lordship, there is no specific provision in the statute. If the statute is required to be changed, then AG sir is required to be heard. AG sir, Advocate General sir is required to be heard. If the statute and the act is
challenging the statute,
if some additional is also required. Next is, your lordship, that why he is filing this instant application at this stage.
Because the market price is much higher.
Not only
continue for years together by paying a paltry sum of rent.
Let him expedite the trial. Let the trial court decide.
That is a different thing. He does not want you to vacate. He wants the market rate of rent from you.
Lordship, in that respect, he can file a suit of eviction in respect of ground that fair rent must be considered.
Show me that eviction, that ground is contemplated under section 6.
There is a provision of fair rent, your lordship.
No, for that eviction is possible. Show me, section 6 contemplates that. You want to cite any decision?
No, Your Lordship. As of now, I'm not having
Anything more you want to submit?
No, Your Lordship. Let the trial be concluded expeditiously, Your Lordship.
Yes, Mr. Bose.
My lord,
Anything in reply?
there is also one judgment, if your lordship will see, it is referred in para 33. I just wanted to give your lordship the copy of that, which is Muhammad Ahmed. It is referred in para 33, if your lordship kindly takes this. Para 21 of Muhammad Ahmed has been.
Paragraph?
Para 21 has been quoted.
Yes. Paragraph 21 has been quoted.
Now, if your lordship.
Which paragraph?
At para 33.
33.
In
Oh, yes.
Vijay Kumar, para 33,
Yes,
it has been quoted. Well, this is the, though it's in 2011 itself, my lord, the Supreme Court takes into consideration, kindly see para 21 once, the opening words. According to our considered view, majority of these cases are filed because the landlords do not get reasonable rent akin to market rent. Then on one ground or the other, litigation is initiated.
Why did not approach for determination of the fair rent?
Well, fair rent is unfair. I know, but
There's a
in
provision
the
under
facts
the
of these
statute
cases,
itself.
the fair rent is itself unfair.
That then you have to challenge the statute.
No, well, I can understand, my lord, what is falling from your lordship.
Anything more, Mr. Bose?
No, my lord, I wanted to show your lordship, my lord, that holistic view taken by the Supreme Court, and 21 has been considered in Vijay Kumar in 2024, because para 21 in the judgment of Muhammad Ahmed, which was passed 15 years back.
Yes.
This was a consideration. The Omega situation.
Yes.
Kindly see. So before saying Omega, we deem it our duty and obligation to fix some guidelines and norms for such type of litigation to minimize landlord-tenant litigation at all levels. So what is happening is that, my lord, if a tenant is directed to deposit, I am not saying that he'll pay, I'll appropriate. No. This will reduce the 30-40 years of unnecessary clogging of civil courts. It will go on there, then first appeal, never heard.
Anything more, Mr. Bose?
No, nothing.
Thank you.
End of June, end of this month. End of this month.
End of this month is Monday.
Say next date before the trial court is 7th of July.
Examination, Your Lordship.
7th of July.
Yes, Your Lordship. Cross-examination is going on.
Cross-examination?
Yes, Your Lordship.
So, I'm extending till 5th of July. 4th of July.
Good. May I take your lordship's kind leave, my lord?
Thank you, Mr. Bose. Yes, though this matter is yes, caller, next matter. Passover matter 11. Yes, 11.
My lord wanted to know, my lord, how many witnesses, my lord, I proposed to examine, because, my lord, my witness section was closed because of, my lord, my consecutive days, my lord, non-appearance in a probate suit where, my lord, I am the propounder, my father's will, my lord, I am the son, executor cum beneficiary. My lord, there are 3 attesting witnesses. Fortunately, all of them are alive.
8 adjournments. Per day cost, Mr.
I leave it to your lordship, my lord, I cannot bargain. My lord, I leave it to your lordship. But my lord will kindly, my lord, have some mercy. My lord, this much, my lord, I can, my lord, most humbly submit. My lord, may I just indicate number of witnesses and my lord explain why? My lord, 3 attesting witnesses, all of them, my lord, are alive. So, my lord, 3 of, my lord, the attesting witnesses, the propounder is being examined, and, my lord, the brother of the propounder.
5 witnesses. Have you filed the list of witnesses?
My lord, I will file, my lord, on the returnable day. Or Milord by put up, I can file it Milord on Monday also. Milord, I Milord make it note Milord to my learned friend.
Yes, anything?
Lord, we kindly direct them to conclude the entire evidence within a certain period of time.
You are the propounder. You are not diligent, Mr. Banerjee.
No, Lord.
Shows your proceeding.
Milord, facts are
Lord, the father's property partition suit was filed by the married sister. Then after filing of the Lord, the partition suit, Lord, these two will brought to the surface.
This application In case you find, that the next date is far off, please mention the upon notice to Mr. Banerjee. So that Mr. Banerjee, I will only modify to that extent. I will direct you to pay within that time, and I will give him liberty to prepone that.
Lord, may I be permitted to take back orders of Lord certified?
Yes, yes. Order sheet, only order sheet diye din. Yes, call the next matter.
Item number 18, my lord, I am for the petitioner. My lord, pursuant to lordship's direction passed on 7th of May 2025. My lord, on prayer of both the parties, the matter was sent to mediation. Mr. Chandan Ghosh, my lord, he has entered appearance. We have sat once. My lord, probably it can be settled. My lord, the second date has been fixed on July 14th. My lord,
July 14th.
So,
You are keeping it, when do you want?
my lord, in the month of August, if it commences to your lordship, because he has given some home tasks for
It's
both
your
the
other
parties.
side.
My lord, he is not there. My lord, your lordship, pursuant to your lordship's direction, the matter has appeared today as
No, no,
for
no,
orders.
that is there.
My lord,
Suggest a date.
my lord, any date, my lord, in the first week of August, because on 4th July,
6th of August.
6th of August, 6th of August.
Ashun. Mr. Shur, learned advocate, appearing for the
That caused the entire thing, my lord.
Let me see this, that
Yes.
matter,
My lord, let it be tagged together, otherwise, my lord.
not
we are-
now, the learned Coming after 5 minutes. Yes, call the next one.
21, I am asking for the petitioner, my lord. This is the application, my lord, as the wife is living separately with a person to whom, against whom, my lord, and a complaint has been lodged by the husband, being the father of the minor girl, under the POCSO Act, my lord. And as
Which order you are challenging?
my lord, I have not challenged, my lord, for which, my lord, an application for custody has been filed. But till date, my lord, one after another application, my lord, date has been exhausted, my lord, by taking prayer. And my lord, time prayer, my lord, and my lord, till date, my lord, the application for interim order, my lord, that has not yet been disposed of, my lord.
This application under Article.
I am the plaintiff decree holder, Your Lordship. I filed an execution. In that execution case, Your Lordship, this case was filed under section Order 21, Rule 99, 101, Your Lordship. After evidence, there was a document which was exhibited by them, the signature of which I have challenged, Your Lord. I say it's a forged signature. So I filed an application before the learned executing court asking for an expert opinion of
Where
the
is that?
signature.
Where is that application?
My lord, the application starts at page 40, annexure D.
40.
40, Your Lordship.
Which is the admitted signature?
Your Lordship, A series, Your Lordship, my contention is it has been proved to the satisfaction of the court. Under section 73, Your Lordship.
A disputed signature is to be compared with the admitted
Signature.
Show me the admitted signature.
Or a signature which has been proved to the satisfaction of the court, Your Lordship. That is what the statute
Yes.
says.
Show me what is the signature which has been proved to the satisfaction of the court.
Exhibit A series is a document of counterfoils of the rent receipt books when Vitani Devi was acting as a.
Show me that it has been, the court was satisfied.
The court has not been satisfied. It has
Then-
recorded also why it is not satisfied, Your Lordship.
Then how can it be compared with that?
It merely holds that it has to be compared with if
and to have been written by the person may have been compared with the one which is to be proved.
Admitted signature or proof to have been admitted.
I have given my evidence to that effect, proving the document, your lordship.
Show me that.
But the court
Unless-
fails.
Where is the evidence act? Evidence act. You have a copy of the. There any change in the new act?
No, your lordship.
So either it has to be admitted or proof to the satisfaction
Section
of
of
the
the
court to have been written. Show me that it has been proved to the either admitted or proved to the satisfaction of the
My
court.
contention, your lordship, if the court is dissatisfied with the proof, your lordship, it
Cannot be compared with that.
it has to be recorded, your lordship. He merely holds. My lord kindly comes to the last page impugned order, your lordship.
Yes.
The signature of the document which has may I read out the entire paragraph, your lordship. Exhibit Bitani Devi on document marked as Exhibit 2 with the document filed by the OP1 marked as Exhibit.
Yes, has not been proved to the satisfaction of the court.
But
There is
yes,
a recording to that effect.
but why it is
This
my lord
application-
kindly appreciates, your lordship. This is a
Please
document.
produce a admitted signature. It will be compared with that.
My lord,
Two disputed signatures cannot be
my lord,
compared
if
with.
this application is dismissed, your lordship, they will take the plea of res judicata, your lordship.
I will
Kindly
give you,
consider-
if you produce an admitted signature, it will be, I will give you that leave.
My lord, Annexure AC, the Exhibit A series, your lordship, is a rent receipt which she, while being a receiver by appointed.
Show me how it was admitted into evidence.
My lord, kindly gives me. I have asked my clients to procure the evidence, your lordship.
Without that, you have drafted the petition.
My lord, I didn't have the certified copy, your lordship. I had my lord knows the handwritten copy of the evidence, your lordship.
After some argument, the learned advocate. Will appear in due course.
My lord, the difficulty is the trial court is proceeding, your lordship. The evidence has been concluded, your lordship, and the arguments will proceed, your lordship.
Yes, Mr.
How the learned district judge, my lord, accepted the revisional application. But what happened, my lord?
How the learned district judge
accepted 115 of the Code of Civil Procedure.
Ask the learned district judge.
My lord,
So Mukherjee asked the learned district judge how the learned district. How can I say from here?
no, not required, my lord. Kindly see the order.
What do you want, Mr.
I
Mukherjee?
can see. The entire order, what happened, my lord? Suit is at the preemptory stage.
Is
Suit
this
was
an
filed.
expeditious hearing?
No. Suit was filed in 2015. Suit for declaration injunction.
Yes.
Now, my lord, I have stated that the private respondent has encroached a part of my portion. Now, my lord,
According to you, civil division is not maintainable.
yes, sir.
Have you filed any application raising the issue of maintainability? Where is that?
Kindly see from the fact itself, my it is not made. Kindly see once, madam.
Have you filed any application for maintainability?
The district judge himself recorded. Kindly see order number 3. Why I am telling, kindly give me 2 minutes time. I filed a suit for declaration injunction saying that encroach the property. Partition commission, surveyor's commissioner was appointed. He submitted a report saying that there is no encroachment. I filed objection. Court below rejected the same. I came up before this court. This honorable court set aside that order. Now, my lord, directed for appointment of fresh commissioner because once upon a time he was the advocate of that side. Now, my lord, ultimately new commissioner was appointed. He, my lord, done the commission back and submitted report saying that yes, there is an encroachment. That report has been accepted. Now, my lord, kindly see the order accepting commissioner's report. The matter has been fixed, my lord, for peremptory hearing of the suit because it is 2015. There is a 4th direction passed by this court to dispose of the suit within 3 months. Now, my lord, after that, my lord, when the suit has been fixed for peremptory hearing, kindly turn to, my lord, the revisional application
Civil division passed filed against which order?
accepting commissioner's report. But
Accepting commissioner's report.
yes. Now, why that has been filed? Just to delay and second day call for the record. Entire record has been called for. My suit has been gone. Now, kindly see, my lord, first, my lord, the order accepting commissioner's report.
Mr. Mukherjee, make a submission before the learned district judge. The records need
kindly
not be,
see that from
trial court records need not be called for
already gone. Kindly see order number 3. Kindly see order number 3.
Yes.
Order number 3 days 6 May 25. Having heard the submission and having perused the impugned order, the civil division is admitted. Call for TCR. This is an applicant under section 150 CPC paying for revision of the order dated 21 to 25. However, in view of the peculiarities of the facts of the case, question of maintainability is kept open to be decided at appropriate stage. Then call for a record transferred to ADJ. Then kindly see next.
Enter appearance.
Kindly see next page. Receive the case record without LCR from the district judge. Then next order LCR has been tagged. Then ultimately, kindly see order number 6. LCR has been received, let it be tagged with the record. Fix 4925 for copy service of summons positively. I entered, after that I enter appearance. Now for the 1 minute this order is not maintainable. For 1 second this order calling for the record and stay for
1 second.
Kindly see
6th of June till we are in 25th of June.
When I received the summons, kindly see. But the kindly
Mr. Mukherjee, you apply before the learned trial judge, raise a point of maintainability, direct in the revisional
court. But kindly visualize only one thing. But after the what we learned, but after the amendment of Code of Civil
Come
Procedure,
from where?
from your Lordship's court.
No.
From 1st July 2002, this is absolute tactics for dilatory. My client is aged about 79. Kindly visualize there is a 4th direction passed by this court. Number that their intention only to call for the record that has been done. Now every time interim order is extending. But kindly see the trial court's order. But trial court court fixed peremptory hearing. But kindly see order number 104 at page 16, 16.
What is the next date fixed, Mr. Mukherjee?
September. But kindly see by order number 6. Fix 4925 for filing copy of the service of summons positively.
This court could not.
I am instructed. May I submit one thing?
So decree 27 is the right.
My lord, before my learned senior friend starts, may I submit one thing? I am instructed to appear on behalf of the opposite party lordship.
He says civil division is not maintainable.
No, he cannot say.
No. What did you say? He said decree.
Say this is work of tribunal decree, so this is in fact a first appeal.
Oh.
My lord, may I submit lordship?
When you have said, I have only heard the decree. So,
my lord, may I submit?
When I heard the decree, I thought that through mistake this was filed against the decree.
My lord, my junior has told me that his client has received the copy just yesterday.
Caveat was there?
Yes, there is a caveat, lordship. Kindly fix it on 4th, lordship.
I have no problem, my lord. Can you stay the decree? Let it be heard out.
Contested application.
Yes, lordship, kindly. Let it be heard, lordship. Fix it on 4th, lordship.
4th,
lordship, kindly.
When? At what time? subject to convenience of both of you.
Subject to
Past for the limited period, I'm kept it on court. I've kept the matter on court.
Preemption is the petition of your
কোনটা? হ্যাঁ ওই কন্টেস্টের আপনি ওইটা হার্ডার ল্যাঙ্গুয়েজ ওইটা কেটে
Petition has been filed on the ground that the petitioner is the adjoining owner to the land state. And the opposite party entered appearance and said, I am not the adjoining.
You are not the
adjoining owner. And the trial judge dismissed that preemption application holding that as I am a co-sharer, therefore the preemption application is not maintainable because I am not the full owner of the plot of the land. Already your lordship knows a portion of a land is entitled to
Ulakundu.
Ulakundu. I have judgment of Ulakundu.
Now, what has been Ulakundu was not referred to?
No, my lord, but
why?
Till date, my lord, I do not find, my lord. But these judgments,
no, Mr. Ghosh, Omolgiri has been referred to. I think Omolgiri has been distinguished.
My lord, can you think Omolgiri's judgment, my lord? Because this judgment, my lord, Ulakundu has not been considered.
Omolgiri is a subsequent one.
Yes. Kindly sees, I have bought this judgment for your lordship in 2004 voluntary session, my lord. Your lordship kindly sees the cases reported. Your lordship will not find that the Bulakundu judgment. Well, this is a judgment.
Where is Bulakundu?
Well, Bulakundu judgment is, my lord.
2000 CWN.
CWN. This is 2003 volume 1. Possible, I do not know what is
2000 CWN. Then Mr. Ghosh, it is to be referred. Mr. Ghosh, it is to be referred then.
You also do refer it, but in the meantime,
Mr. Ghosh, what is 1995 WBLR Cal 263? But Rekharani, what has been said? That's also on precedence. Because the earlier decisions have been referred to.
Earlier decisions have been referred to, my lord. You will also kindly sees that judgment, my lord, the Bulakundu.
This is Bulakundu.
Yes, Bulakundu's judgment, my lord, the Rekharani Maitri's case has been considered.
Rekharani has been considered.
Yes.
Rekharani is 95 WBLR.
Yes. It has been considered in Bulakundu's judgment, and Bulakundu's judgment, it has been found, my lord, the adjoining owner, if he doesn't become.
That was also my impression that even a co-sharer, yes, because he has right over every inch of the property.
Absolutely.
That's the logic of.
And the court says, since there is no partition under section 14 of the Westmoreland Land Act, my lord, therefore this preemption application not maintained.
Because one thing, Mr. Ghosh, unless there is partition, how can you decide on the longest common boundary?
One longest common boundary, because there is only one portion, that is my brother. He has not filed any application for preemption. Therefore, my lord, there is no question of longest common boundary in this particular.
No. I could not follow. There is only one other co-sharer is
my brother.
Your brother.
Pratap and Praful are the two brothers in respect of 2094 and 2091. The court came to a finding, since there was no partition under section 14 of the Westmoreland Land Act. Therefore, there is you become a co-sharer. You are not.
And the preemptee do not have any adjoining land.
No. Total plot of land on the northern side, my land, and in eastern side, my land. 3094, 3091.
To be referred. Two coordinate bench decisions.
Your lordship kindly passes an order. It did come back before your lordship, then my lord, on the day when the other side appears, my lord, then your lordship can pass the order.
Mr. Ghosh, there is no subsequent decision considering Omolgiri. I think faint recollection, Omolgiri was considered in a.
I should be frantic, I have not searched it out.
Omolgiri, I think it was.
On the next day when I come back, I check the paper. The meantime, if it constructs a house, then my lord, it will be a very difficult task.
Everything will best. He will get a constructed house, Mr. Ghosh, where he will get the property.
You lost the kind of status quo as regard nature, character, and possession also.
Status quo is a very difficult thing. Not to create any third party interest, but there is no pleading in support of.
I know, my lord, you lost me.
Per alienate, yes. I do not know because status quo is something very difficult.
Very good. I get it, my lord. 26 my lord, the same, my lord, the
26 of same. They can even should do number different.
yes, the
Why
case,
two preemption
my lord,
applications?
there are two plots of land, my lord. There are two co-sharers, my lord.
Two plots of land.
Yes.
They
I
can
get
even otherwise same.
দাদা, এটা কি থাকবে?
26, 25, 26 same order.
Judgment will depend on the lordship file.
Can take back judgment will deal.
দিয়ে দিন আমাদের পরে কাজে লাগবে ওগুলো। I'm grateful to your lordship.
But bring it on the next occasion because I have referred to that.
Yes, yes. Right.
And also please consider,
Yes, I
my
shall-
faint recollection is that Omolgiri was considered substitute.
Subsequent. My lord, I shall immediately today in night, my lord, I shall.
That's my faint recollection. I cannot. And Mr. Ghosh, can you give me the reference of Jagat Narayan Singh? I think 1992 or 1992.
The output appeared in this particular matter. My lord, I
Who is appearing? Yes, yes.
Lord, I shall give it to your lordship.
I think 1992 or 1991.
Can you give me one this time, my lord?
Yes, yes, yes.
I'm appearing on behalf of the petitioner, my lord. Suit for declaration and injunction filed by the predecessor of the petitioners, my lord. There, my lord, an application under section 151 filed by the petitioners for repairing that has been rejected. Challenging the same, my lord, I have come before this honorable court. My lord, application is at page 32.
What materials you have brought before the honored trial judge to show the condition of the suit property?
That is the problem, my lord. That has been no local.
That is the problem,
While
madam.
grant liberty, my lord.
What
file the
liberty is
application,
always
my lord.
there. Liberty is always there.
In the schedule, my lord, it has been stated that to remove the Chitabera walls along with doors, windows, and
Where is your
by
application? Where is your application?
32, my lord. Page 32. By replacing the new bamboo Chitabera walls with doors and windows in its place.
Application is very vague.
And replacing. Everywhere, my lord, it has been stated to remove and replace. But the court has held that no structure exists. It has already been collapsed. The structure is still existing, my lord.
Along with materials on record, what materials have been produced? The honored trial judge arrives at a finding. What is the suit for?
Suit for declaration and injunction, my lord.
You are the defendant. What is the stage of the? You are the plaintiff.
Yes, my lord.
What is the stage of the suit?
My lord, SR ready upon the substituted defendants, my lord.
No, prior to that, what was the stage?
Leader commissioner was appointed, my lord. Kindly grant liberty to, my lord, file the application for local inspection, my lord. It has wrongly held that it has already been collapsed in the order imputed, my lord.
This
Number 28.
Lordship, this is my application. In a suit for partition, my lord, I am for the plaintiff. Lordship, there are total 105 defendants, Lordship. Preliminary decree was passed in the year of 1991, Lordship, which was Commissioner's report was filed in 1996. Subsequently, that was accepted, my lord. Thereafter, defendant number 15 Ko to 15 Runga came into the picture, and they filed an application for separate preliminary decree and also an application for stay of the final decree. Lordship, we have in the meantime deposited our stamp duty and all that. Lordship, now the landed trial court has stayed the issuance of final decree. Everything is in
To be
stage.
done unless that is
But
adjudicated.
Lordship,
after
they
the
have
final
not challenged that initial preliminary decree, Lordship. They have
Maybe,
claimed for a
but
separate
even
preliminary
without challenging, Order 20 Rule 18 is there.
But my lord, I have already deposited the
Maybe,
stamp
but
duty.
Order 20 Rule 18 is there.
Lordship, it is the dilatory tactics only, Lordship, and they didn't appear in the initial stage.
That has been stayed. Let that application be. I am expediting the hearing of that application.
So at least direct that because the suit is a quite old. 1984 suit.
Please kindly come to Order 20 Rule 18 Sub Rule 2. You have not got the book, yes. Order 20 Rule 18 Sub Rule 2. Right hand page.
Yes, my lord, but there was an administrative.
I'm expediting that hearing of that application.
That is time frame, my lord.
This application under Article 220. Post office.
Application for amendment was refused by the learned tribunal, railway claim tribunal.
Yes.
My lord, may I submit one thing? My lord, in the claim application, actually I mentioned that I have no co-passengers, or I have not possessed any tickets. My lord, after that, my lord, upon receiving the summon, my lord, railway authority came with an WS with the DRM's reports, consist of RPF report and consist of police report. From the said report, we find that the police personnel are able to find some person who is the co-passenger of the deceased. I am the son of the deceased, co-passenger of the deceased. He has the ticket with ticket of both the disease and for himself. That was disclosed by the railway authority from their report.
Can that be a ground for amendment?
Huh?
Can that be a ground for amendment?
Not in WS,
yes, they have stated they have disclosed some facts in the evidence. Now you are trying to fill up the lacuna in evidence.
My lord, kindly allow me. This is beneficiary legislation. Kindly, I have not changed the nature and character of the suit. I only
You are trying to fill up the lacuna.
No, that is, my lord, allow me. My lord, Reena Devi 2022. If I have not possessed any ticket, I also able to get the benefit of the claim. My lord, kindly consider that. But kindly, what I want to suppose to feel, my lord, kindly come to page 18. Page
18. Where is your application for amendment?
Yes,
Where
lord.
is your original claim application? Where is your application for
Yes,
amendment?
original claim application starts from page 14 and 14.
Yes.
And amendment application at page 68. And may I submit one thing?
Where is that you have stated that there was no other co-passenger? Where is
Yes,
that?
lordship. Page, my lord, this is
in the original claim application.
Yes, lordship. Kindly come to page 18 2C.
18.
2C. EPS, do you EPS did give details of the ticket? Ticket was recovered by the police authority. And 3A, 3B. 3A and
was there a co-passengers with the victim?
Of the
So you have
accident,
said no.
I said no. My lord, kindly visualize the situation. Being the
Now
applicant.
show me the amendment application.
Now, my lord, kindly come to page 68 is the amendment application and page 70 is the schedule of amendment. My lord, may I show one thing?
You are trying to make out a new case.
No, my
You are trying to withdraw the admissions.
no, this
Yes,
is
some portions of the claim application you have sought to delete, inserting by.
no, my lord, kindly consider.
Yes, kindly come to page 70.
Yes,
So,
lordship.
column number 8, some portions the ticket was lost. You have
But-
wanted that to be deleted.
My lord, may
You
I?
can, sir, you can explain the admissions, but you cannot withdraw the admission.
May I submit one thing? May I? May I kindly visualize the situation? Accident took place in Mosagram. Being the applicant, I in Bankura Patrosai PS. But this is 110 kilometers distance. It is not possible for me to get the ticket from after reaching the place of accident. My lord, it is came to their report. My lord,
Sir,
kindly
that is
consider
on
that.
merits, that is on evidence, what will be proved. But in
But
the application
kindly
for amendment, some portions you have sought to withdraw that.
I am not.
You are trying to insert a different thing. But
I'm not.
show me that is permissible by way of.
As it is a very minor, kindly come to page 36 once. Their report, kindly come. They investigated from their report. I came to know how before filing of this application, it was not gettable for me. But
Sir, you are filing an application. You know the facts. You have to make out your case. When the other side will file a written statement, then after getting knowledge of that,
they are supporting my case. Madam, kindly consider one thing. Madam,
sir, if they are supporting your case, take benefit of that admission.
Kindly, page 36, for once. Page 36. Madam, kindly consider page 36.
By the order.
My lord, I am for the petitioner, my lord.
Yes.
My lord, I have challenged my signature, my lord, in the.
Yes. You have challenged your signature where?
My lord, page 20, my lord.
Page 20.
Yes,
what
my
is the suit for?
My lord, this is a suit for, my lord, for arrear salary of the workmen. They are saying.
You are the workman?
No, my lord, I am the owner of the shop.
Yes. Where is the order impugned?
My lord, kindly, last page, my lord.
Against the order of the industrial tribunal, there is no provision of appeal. You are appealing for the opposite.
No, my lord, please with me.
No, I'm my senior is with.
There is no provision of appeal.
My lord.
Is there any provision for appeal against this order of the industrial tribunal?
Appeal provision.
So please check up. Yes, please.
Lord, this is an application against the order passed by the appellate court in an executive.
How do you know?
Lordship, the appeal court has directed us to pay a sum of rupees 30,000 per month.
Yes. Occupation charges.
Occupation charges. The occupation charges was 250, and the decree says that it is to be paid at the rate of 50 rupees per day.
Decree, mean profit decree.
Yes.
That's different. Mean profit decree and occupation charges, stand completely on different footings.
There was
So
no,
this was considered. That was the earlier view. Division bench judgment is also there.
Lordship.
So I had the occasion to appear and a beneficiary of that decision.
Lord,
But now the law has changed. So there has been a distinction. It cannot be at the rate of mean profits claimed in the plaint.
Lord, here the decree says it is 50 rupees per dime.
So that was the, even if the decree a rate has been quoted for mean profits, occupation charges can be at a higher.
I'm not on that. I'm not on that. The appellate court has said that you pay 30,000 rupees. 50 rupees per dime comes to 1,500 rupees. If your lordship takes.
What is the suit property? What is the suit property?
Procedural Road.
It's a commercial place.
No.
Residential.
Residential. And
what is the area? What is the extent of your occupation?
Lord, 800 square feet possibly. And my lord, the decree says 50 rupees per dime. And the appellate.
No,
I'm not on that.
50 rupees per dime. That was the.
My lord, I'm sorry. It is 1,223 square feet.
1,200 Protapaditya place or road?
Road.
30,000 is reasonable, Mr. Khan.
Lord, the decree says 50 rupees a day.
Decrease mean profit. There are decisions. That was the earlier view. Now it says occupation charges can be more than that. Because that is the mean profit, this is occupation.
Lord,
as a condition for grant of stay.
There is no basis for charging 30,000 rupees. No.
What materials you have produced for ascertaining the occupation charges?
The trial court did not rely on any materials. Does not, trial court did not depend on any materials.
Stay application disposed of
Stay
or pending.
My lord, if your lordship comes to the order, let there be an order of stay of the execution, case number so and so, arising out of judgment and decree dated so and so passed in connection with ejectment suit number so and so. Yet in the till disposal of the instant appeal. However, subject to payment of occupation charges, appellant in favor of the respondent to the tune of rupees 30,000 per month. And my lord, the decree is at page 40.
What is the stage of the appeal? I can expedite the appeal.
It has just been admitted, my lord. Paper books possibly has not been filed. Your lordship can expedite. But my lord, what about the interim payments?
30,000 is a reasonable. 1,200 square feet. What is the market rate now, according to you, in that area?
Lord,
and if it is less, the tenant will easily vacate and fetch another accommodation.
No, my lord.
So it's very difficult to get a 1,200 square feet flat in Protapaditya Road at a monthly rental less than 30,000.
Lord, it's not a question of whether what is the current rate. Question is if the tenant is entitled to continue as per the stay, what should be the quantum of payment?
Current monthly rate. That's the criteria for the fixing of the occupation charges.
Therefore, my lord,
because the landlord is being prevented from enjoying the fruits of the decree. If the landlord, suppose today gets the property, he can fetch that 30,000. That's the test.
My lord, it's a 100 years old property. They are continuing at the rate of 255. I am not saying that I am entitled to continue at 255. I am not saying.
That is the reason why Attaram came. 2005 came. That's the reason.
Now, my lord,
225 up to second appeal, that rate was being continued.
Now, my lord,
that's the reason why Attaram came, and it's the law now. And there was a, you have rightly said that a mean profits, that issue now has also been settled.
No, my lord, I am on this. That where is the basis of this 30,000?
You have also not produced any document to contradict this. Show me in your revision application, you have produced any document showing that the rent cannot be that.
My lord, court will fix a rate. And I did not know that they will be fixing a rate at 30,000. Where is my scope for showing to the court that it was much less than 30,000 rupees? Expired at the time when this order was passed, there was no material before the court as to whether it is A or B.
All right, you serve, let the other side come.
Very well, my lord. But, my lord, whether I have already deposited the rent at the
deposit, I am not interfering with that. Please deposit. If it is modified, it will be adjusted. The petitioner is aggrieved by what's the reference?
My lord, this is 1992 Calcutta 216.
1992. So here I was এইটা না এই যেটাতে ফরওয়ার্ড করেছিলাম দুখানা সকালবেলা যেটা হলো মইনাক বোস ওইটাতে লাগিয়ে রেখে দাও Thank you, Mr. Ghosh. Yes. That was the suit on the ground of expiry of lease.
32, my lord, I am for the petitioner. My lord, I am for the defendant of title suit number 1772 of 2027. My lord, I am paying for expeditious disposal of this title suit.
Expeditious disposal of what?
My lord, title suit number 1772. My lord, plaintiff filed for.
No, what is the suit for?
My lord, declaration and my lord, injunction.
What is the stage of the suit?
My lord, I filed order 7, rule 11. My lord, that was pending. My lord.
Defendant number 2 has not yet appeared.
My lord, defendant number 2 is the my lord, promoter. My lord, I purchased land from the
expunge him.
And my lord,
expunge him then. If you don't want the defendant number 2.
Principal defendant, your lordship. I am the principal defendant. My lord, I
unless the defendant number 2 appears, the suit cannot be expedited.
I purchased land from.
Yes. Expunge him then. This application under Article 227 of the Constitution of India.
Whether the production of document before framing of the issue.
Production of
documents. We sought for it. We sought for production of documents, though it is incumbent on the part of the plaintiff to produce the documents along with the plaintiff. In view of the amendment, order 30.
Yes.
Now
directed to produce the original.
Yes. And framing of issue. It should be before framing of issue.
It should be
before framing of issue. Managally consider order 13 rule 1.
No. You are challenging the order dated 18th of March.
Yes.
Who are you?
I'm the defendant. 18th on 9th July 2024. Your lordship.
9th July. You are challenging after a long time.
No, there is a first
18th
order.
of March is the last order.
No, before that, I want to draw your lordship attention. Can turn to 9th July 2024.
Yes.
The first direction was given.
Plaintiff was directed to produce the original documents. Yes. On the
and
next
for framing of issue.
Yes.
Now, my lord, can you turn to
18th of March?
Yes.
After that, because this is not that this is the first date. It was earlier directed. And
Yes, what happened?
Then my lord, 16 January 2025.
16 January, today is fixed for issue not framed. Yes.
Adjourn for framing of issue. Next, my lord, if your lordship kindly consider. Ordering portion. Once again, the plaintiff is directed.
Put the petitions filed by the defendant stand. What are the two petitions?
For production of the original.
Yes.
And the correction of that order. Because there is a.
Again, the plaintiff is directed to produce the original authenticated copy on which he relied in the meantime by the next date positively. So
And
direction is
fixing of
there.
hearing. And fixing of preempted hearing. PH.
And frame issues framed without production.
Issues have been framed.
Framed. So, therefore.
Mr. Rai, if the documents are not produced, you can take the benefit of that.
No, my
There's
lord,
a
kindly
provision.
consider. I could understand it has not.
Order 11.
Order 13, rule 1.
Order 13, rule
1.
Yes, original to be produced
On or before the settlement of issue. And there is a, my lord, why I am submitting this, my lord, there is an amendment which came in with effect from 1999, this amendment. Previously, if you
Give me a minute, Mr. Rai.
my lord also delivered the judgment.
On what?
This order 13 rule 1. If your lordship wants, I can produce the same also. Rightly, wrongly, benefit to my any.
That is a different matter. This is also a different matter.
No, scope of order 30 rule 1. And my lord, can you consider order 13 rule 2? What is following from your lordship? What will be the effect for non-filing of the document? That was omitted.
Yes, order 13 rule
2. Effect for non-production of document.
That has been omitted.
That has been omitted. Therefore, my lord, it is now mandatory.
No, mandatory at what stage?
Before framing of issue. If my lord wants to elaborate that at the time, only for the purpose of cross-examination, I could have understand. The documents relied upon by the plaintiff with the plaint that must be produced. There is distinction, my lord, pre-amendment and post-amendment. Pre-amendment, there is provision that subsequently upon leave of the court, I can file the same. Post-amendment, that portion has been omitted.
Show me that.
Pre-amended.
Pre-amended.
My lord, this is an elaborate judgment, though it is passed by Karnataka High Court. But everything, post-amendment, pre-amendment and considered. My lord, I am drawing lordship attention from paragraph 11 onwards. Considering the post and pre.
So this is order 7 rule 14.
Yes.
So the documents have to be produced along with that.
No.
So I think in order 7 rule 11 there has also been an amendment.
Yes, paragraph 9. Order 30 rule 1 also considered. Paragraph 9 of this judgment.
Paragraph
9. Because two provisions are there for the purpose of production of documents. One is 13(1) and the order 7. Amendment was considered. So it has persuasive value, what? That is why we are carrying 13 and 14.
If the additional evidence can be produced even at the appellate stage.
That is why, my lord.
At the appellate stage.
That was also considered. Order 40 rule 27 was considered in that aspect also.
That is there.
That aspect also considered.
Can he be non-suited for that? Can he be If at the appellate stage, a party can produce.
Yes.
Can at the trial stage, all right, serve a copy.
I am praying for stay, preliminary hearing. And my lord, there is no exception. So what is followed from my lordship? What will be the effect for non-production of the same? That was consciously omitted by the legislature from 1999 amendment.
Then what is the effect?
That, my lord, that is,
If that has been omitted,
they are, my lord, showing good cause. The amendment, that rule 2 was that if you showing cause, the court can allow. My lord, pre-99 amendment subject to question, my lord.
no, that I've seen.
That is for admission purpose, my lord. Privacy. After that, my lord will go into the merit. And the that is a violation. That was considered in Canada High Court, and it was held that legislature consciously omitted that portion by withdrawing the leave, the power granted to the civil court for acceptance of the additional document subsequently after framing of issue. এত বড় কি ছোট ইয়ে করেছে এত portion. Well, that means it requires consideration as my lord is so much involved in this issue. My lord can decide this issue.
There is substance in the argument of Mr. Royal Honorable.
That was there. Karnataka High Court has
That I've seen.
Paragraph 14, my lord will find.
May operate harshly against you also. Yes.
Number 34.
34. Yes.
Kindly see the first order, my lord. I filed an application under order 41 rule 19 for readmission of the appeal since the appeal.
Chakraborty, can you come at 2 p.m.?
Yes, my lord, I'll come, my lord. Another matter is there, my lord. Code number 36 fixed, my lord.
36.
Yes.
All right. What is this? What is the impugned order?
My lord, kindly see. First order, my lord, kindly see. I filed an application under order 41 rule.
Which order you are challenging?
My lord, actually, last order I am challenging, that is order number
19th of March.
11th of March.
No, 19th of March is under challenge. In the cost article, you have said 19th of March.
No, it was, that means that will be 11th of March, my lord, wrong with that man. 11th of March. My
You
lord,
will be mentioning wrongly in the cost article, and when in the order it will be mentioned, you will say typographical.
I am seeking leave, my lord, to correct. My lord, kindly see first
11th of March.
11th of March.
Yes.
My lord, kindly from first order, it will be, my lord. First order, my lord, I filed application under order 41 rule 19. My lord, that will be appearing from the first order, my lord. And date was fixed on 9th of January 2025 for SR and AD. My lord, 9th of January, but no date of hearing.
Which order? 9th of January 2025. No, what was the initial order? 29th of September.
Before that, my 21st of September was the initial order.
Yes, 9th of January was for SRAD.
SRAD. On that day, my lord, there was no hearing date, my lord. I filed Hajira. My lord, court, my lord, at 2 to 10, called the matter, and my lord, for my absence, my lord, asked for show cause.
Yes.
On the next date, I filed the show cause, my lord, on 11 March. That show cause was, my lord, verified by my father and affirmed by me. My lord, court question, my lord, kindly see. The court asked the notary public.
Because petition was not accepted.
Not accepted.
So that is order dated 19th of March. Next handwritten order.
No, my lord.
And the miscellaneous case was dismissed for default.
Yes, 19th of March.
This miscase was under what provision?
Miscase was under, my lord, order 41 rule 19. Miscase.
So there is a provision for restoration. You apply for restoration.
That has been dismissed, my lord.
No.
Yes. My lord, I have annexed
the 41 rule 19 has been dismissed.
Yes. That has been annexed, my lord. That is your lordship will find from the next page. Lord, SR date, there was no necessity of hearing, my lord. On that day, so cause file, my lord, myself sign and affirm. My father verified, my lord, that has not been, my lord, accepted. Neither I have disowned nor my father disowned.
Is it not an appellable order?
No. My petition, my petition.
Your petition, order 41 rule 19 got dismissed. Please come to order 43. Rule 1T, an order of refusal under rule 19 to readmit. It's an appellable order. এটা দিয়ে দিন।
Actually, order 41 rule 19 was not heard.
That was dismissed. Effect is refusal. What is the ultimate effect? Or you have to file an application for restoration.
19.
Of that order 41.
19.
So this is nothing but a dismissal of a restoration application.
Well, order 41 rule 19, my lord.
What is the effect of this order? Miscellaneous case is dismissed. Yes. That means in effect is order 41 rule 19 is dismissed.
That can be said, your lordship is not wrong.
There are two options. Yes. Dismiss for default. If you want to restore, you can take other steps. But if you want to directly challenge, it's an appellable order because it amounts to dismissal of order 41 rule 19.
In effect, my lord, the order 41 19 is.
So refusal to restore that. By the order impugned, the
July 25. My lord, my lord, within 7 days, I say, think that no return.
Serve within 7 days.
Yes, I can serve, my lord, return, my lord, 1 week after.
Service returns.
Yes,
You try, make a speed post today itself.
all right.
The time for mentioning. Yes, call the list.
Item number 1,
For all the reasons as a yes, call the next one.
item number 19,
Milord, Milord, last occasion, Milord, I couldn't bring it to your lordship's notice, Milord. There are some judgments. Milord, may I just place, Milord?
Order.
Milord, division bench of this court and Honorable Supreme Court's judgment.
Order passed.
Milord, in respect of, Milord, your lordship's query was, Milord, Order 9, Rule 6, 1A, Milord, whether, Milord, I have twofold submission. Milord, regarding, Milord, Order 9, Rule 6, 1A, Milord, court need not fix a particular date, Milord, expert hearing. That is the judgment number 1. Milord, that is no compulsion on the part of the court. Milord, where, Milord, the, Milord, defendant doesn't appear in suit on multiple occasions. This is 1. Number 2, Milord, with regard to, Milord, the Honorable Supreme Court has said, Milord, in case, Milord, defendant fail to appear when it is fixed for first hearing of the suit, there is a distinction between first hearing and thereafter, Milord, the
Order
hearing.
17 rule 2.
Yes, 17.
I've considered order 17 rule.
Lordship, kindly
considered the interplay of order 9 and order 17 rule 2.
Milord, in that case,
I've also considered the earlier provision of order 6 rule 1A after its substitution also.
Milord, I'll be, Milord, failing, Milord, in discharging my duty, Milord, if I do not place these two judgments. Lordship, kindly consider this when whatever your lordship passes, Milord. Order 17 rule 2, Milord. Milord, cast, Milord, courts on an obligation, Milord, either to proceed under order 9 or, Milord, pass appropriate order as it thinks fit. Now, Milord, to act as otherwise, not under order 9, Milord, gives court ample power, Milord, to proceed with the suit ex parte. Because there is a difference between order 17 and order 17, where, Milord, there is a specific, Milord, obligation, Milord, on the part of the party to, Milord, to do something, and if he fails to do, then, Milord, Code of Civil Procedure has taken care of the situation thereafter. But, Milord, order 17, there is such obligation on the part. It is simply because of non-appearance. Milord, court either proceed under or, Milord, court can pass appropriate order. So this is, Milord, the distinction, Milord, the Honorable Supreme Court has made. If your lordship kindly, Milord, in the same line, as well as the division bench of this Honorable Court.
And what is the decision which you are relying upon, that it says that a court need not pass any order for fixing the suit?
Milord, this is reported in year 2004, Calcutta, page 98. Let me just.
Yeah, 2004.
Calcutta, page 98. Yes. Milord, I'm sorry, Milord, it is not stitch stapled, Milord. So kindly excuse me, Milord. Milord, taking into consideration order 9 rule 6(1)A as well as 7, Milord.
Which paragraph?
Lordship kindly sees. Milord, paragraph, it is a short judgment. Milord, may I just read paragraph 11 onwards?
No, this is order 17. Where is order 9 rule 6(1)A considered?
Yes, 6(1)A considered, paragraph 13.
Paragraph 13.
Judgment to
Then, Milord, the ultimate
this will not apply because I've also said that after restoration, no notice was also served. That is
no,
also,
Milord, for that, Milord.
Mr. Chakraborty, if it is not served, it is order 9 rule 6(1)A says summons duly served thereafter. The
Yes.
summons is not served, no
No,
question.
my lord, summon, my lord, he filed written statement. Lordship can.
After restoration, I've said you are obliged to intimate that. That's also the finding.
No, my lord, Lordship kindly, my lord, for 1 minute. My lord, Lordship kindly sees.
Mr. Chakravarti, after restoration, is it not necessary to intimate?
No, my lord, when, my lord, the party fails on repeated occasions, my lord.
I think Mr. Chakravarti, please challenge this. It's better.
No, my lord, I just, my lord, Lordship kindly see, my lord, one more thing, my lord. Lordship kindly see this, my lord, this judgment, my lord. This is, my lord, 1955, my lord. Yeah, 1955 Supreme Court.
Sangram Singh.
Yes, Sangram Singh.
Sangram Singh. The Sangram Singh Order 9 Rule 61A.
61A.
I've considered that.
My lord, Sangram Singh.
Mr. Chakravarti, Sangram Singh considered the old Order 9 Rule 61A.
My lord, I am not on 61A.
I've said after substitution, what is the effect? In 1976, there has been a substitution. Earlier it was, it can proceed ex parte. It did not pass any order, but subsequently thereafter, it has to pass an order. That's the substitution.
Lordship kindly see the conduct. My lord, the conduct is not from day one.
Conduct, it's a different thing altogether.
My lord, one more
If
thing.
you want Sangram Singh, I've considered Sangram Singh.
My lord,
I've considered Sangram Singh. I've considered 64 Supreme Court. I've also considered 2002 Supreme Court.
The last limb of my submission. My lordship kindly visualize for a moment. My lord, this is my judicial application. I have challenged an order, my lord, passed by the learned court below on an application, my lord, allowing their application. My lord, the application is in picture. My lord, they have explained 3 dates of the suit, which was fixed. Initially, my lord, the suit same. It is on the same number. Strings were running concurrently. Now, lordship kindly visualize for a moment. If your lordship grants liberty, exercising 227 jurisdiction, my lord, where, my lord, the court before whom, my lord, the default occurs, my lord, they have to explain good, bad, indifferent, my lord, they have to take out
Good cause.
Good cause need to be explained.
I've also dealt with on
My lord, that in that
read the judgment.
on one thing.
Let me read the
One thing. The last, my lord, submission. Lordship kindly sees this 2025 judgment, although, my lord, it takes care of a different scenario, where, my lord, order 7, my lord, court 227 jurisdiction, my lord, applying, my lord, the principle, my lord, rejected a plaint, the Honorable High Court, although there was no application filed with the court below.
Justice Bakchi's judge.
Justice Bakchi's judge.
I'm aware of that.
Lordship kindly sees.
That is on a different thing altogether.
But my lord, the same principle.
227, it says under Article 227, you have to be concentrated on that. You cannot reject a plaint when it's not in challenging.
But here also, my lord, let them file, take out at least a single application. My lord,
what application?
My lord, what is their application all about? Lordship
Order 927.
No, my lord, Lordship kindly see, my lord, the dates. My lord, the dates, 3 days, my lord, they have explained. My lord, those 3 days, my lord, related to the suit only, not related to counterclaim. As your lordship is indicating, my lord, after, my lord, dismissal of counterclaim, my lord, when it is restored back, my lord, on our application, there was no notice. To that extent, there is no application at all filed by them.
Show me that a counterclaim was a separate number was given. Show me.
No, there was no separate number.
So Mr. Chakravarti, what was restored was as a suit. If you say that, then his suit has also been restored.
No, lordship.
If you say that, they have explained the suit. If the suit has been restored, so everything has been restored.
No, my lord, what
money suit has been restored.
Lordship kindly see what has been restored, my lord, by virtue of the order, my lord, that
money suit. Counterclaim, there is no separate number.
Counterclaim, my lord, lordship kindly see the nature and character of the order passed. My lord, the order passed, and as also, my lord, the nature and character of our application. My lord, we are the plaintiff in the counterclaim. My lord,
you have not filed any application.
Yes.
It's his application which has been allowed.
My lord, for restoration of the counterclaim, we filed.
Restoration you have filed. Restoration you have filed, the counterclaim was restored.
Lord,
but it says money suit restored.
My lord,
number is money suit.
My lord, because my lord, this is my submission. My lord, both the my lord, counterclaim and suit was running analogously.
Are you saying that the suit has also been restored?
No, my lord, suit has
been restored.
Because my lord, in order to restore the
The
suit,
counterclaim was dismissed along with the suit.
yes,
You have paid for restoration of the counterclaim.
my lord.
Counterclaim was restored. Thereafter, counterclaim proceeded.
Yes.
So, in a counterclaim, What was the first order while restoring?
My lordship, kindly treat it as a plain.
First order. Yes, it's ever plain.
Yes.
You have also said.
First order is
You have
the
made
restoration.
a submission that there is no decision which says civil procedure code will govern this counterclaim. That also finding I have made.
Milord, so far as Milord, a person, Milord, on repeated occasion, Milord, fails to appear, Milord, then this Milord rescual Milord action under order. Lordship, kindly visualize in a summon, Milord, the first date for hearing is mentioned in respect of service of under order 5. So, Milord, the first date your Lordship has to recon. What was the first date, Milord? Milord, for counterclaim. Monster, order a monster.
When your counterclaim was accepted, Mr. Chakraborty?
My counterclaim?
Yes.
My lord.
Since you are on this, yes. Now let me see. When your counterclaim was restored?
Yes.
And when your counterclaim was accepted?
My lord, I'll just give you lordship.
When you have put in the deficit court fees on counterclaim?
Deficit court fee was filed on 10th of August 2023.
After the restoration. So as on the restoration, there was no counterclaim in the eye of law. So if you are proceeding with that, yes, proceed with that. Yes, there was no counterclaim as on that date, could not have been restored. Mr. Chakraborty, I have read all the orders.
No, my lord, so far as
I have seen that when you have minutely seen. Please tell me when so on the day of restoration, there was no counterclaim in the eye of law, could not have been restored.
So far as the deficit court fee is concerned,
Yes.
your lordship must be aware of the judgments.
Yes.
My lord, I can put in the deficit court fee even at the time of final judgment.
Chakraborty, prior to that, there was no counterclaim in the eye of law. Summons could not have been served. So after that, show me the summons. First summons.
My lord, the first summons.
Yes. After that, it has to be served. Because only after you have put in the deficit court fees, it's an counterclaim in the eye of law. Could not have been proceeded prior to that. No summons.
Lordship kindly sees.
Mr. Chakraborty, I have kept all those things. I have not entered into that. Since you are inviting, then I will go into that. I've seen all that. Show me
in this
case management hearing. Mr. Chakraborty, a date was fixed for case management hearing. Show me the case management hearing.
Case management hearing of counterclaim.
Yes. That was fixed for that. Show me what is required under the Commercial Courts Act under the case management hearing. Show me that.
My lord, then may I come back with the
the orders? Show me.
Yes, lordship kindly see me from day one.
Yes, I've seen all the records. I've seen all the.
No, lordship kindly. This Sangramsi's judgment. If your lordship kindly, your lordship must have gone through. This Sangramsi's judgment, my lord says, my lord, in respect of Milord, the cross-examination, Milord, which has already been, Milord, it is upon Milord, the witnesses. Milord, the witnesses, Milord, has spent so long of time, Milord, for their Milord, deposition and cross-examination. Then again, he has to come, she has to come. Lordship, kindly see that this judgment takes care of that.
You take it up.
No, Milord, when your lordship is here, Milord, I am not, Milord, considering Milord going up.
Mr. Chakraborty, that is why I have said, please kindly come to show me how, what was the case management hearing? No, it's a mandate under the Commercial Courts Act. Show me what is required under the case management hearing. A date was fixed for case management hearing. Please kindly come to the order dated 11th of August 2022.
11th August?
Yes. A date was fixed for case management hearing of the application. Show me the case management hearing that is to be done.
Lordship, kindly see fixed 29th of September.
Yes.
2022 at 12.
Yes, show me the case management. What is required under the case management? Kindly come to the Commercial Courts Act, case management hearing. Issues are to be framed. Everything are to be done. Show me the framing of issues in the counterclaim.
Milord, counterclaim, Milord, yes. So far as this is concerned.
Case management hearing, counterclaim issues, देखिए Commercial Courts Act दिन.
কেস ম্যানেজমেন্ট হিয়ারিং তো ফিক্স ছিল না, এই যে লেখা রয়েছে শিডিউল ডেট অলসো ফিক্স কেস ম্যানেজমেন্ট হিয়ারিং। করেছিলাম after hearing the acceptance of contract. Yes. The registration for list of witnesses.
Yes, Order 15A, Commercial Courts Act. Show me that these procedures are followed. First is framing of issues.
Yes.
Show me the framing of issues in the counterclaim. Written statement was there. Court was obliged to frame a issue on the counterclaim.
Written statement was there. Lordship.
Yes. Show me the issues were framed in the counterclaim. No procedure
No, my lord,
has been followed.
my lord, Lordship kindly sees, my lord, 19th of September's order.
Yes. 19th of September of
2023. My lord, the
2023.
Yes, my lord.
Yes.
This is, my lord, post restoration. Lordship kindly sees.
Yes.
Today is fixed for taking necessary steps regarding list of witnesses.
19th of September.
24.
No, show me for framing of issues.
My lord, framing of issues, my lord, I do not.
How can the court proceed without framing of issues?
Now, Lordship kindly sees.
That is mandatory as per the case management hearing. Can I proceed, Mr. Chakraborty, without framing of issues?
Milord, so far
I have not, Mr. Chakraborty, I have seen the entire orders. So if
Milord, it is
you
Milord,
invite-
it is a bounden duty on the part of the defendant in a suit, Milord, to raise all these points.
Mr.
Milord, they have to
Chakraborty,
raise.
this statement has been filed.
Yes.
This statement has been
Then they
filed.
disappeared. Milord, what is Milord? Lordship kindly sees. Milord, order 8 rule 10. Milord, non-filing of written statement. Milord makes Milord court Milord to pass judgment.
Non-filing of written statement.
Then Milord filed. Then Milord non-appeared. Milord, it is not a case that on the first date of hearing, Milord, he didn't appear.
Give me the judgments. I will close.
Milord, I'm relying on Milord these three. Milord, this Sangram Singh probably your Lordship has taken care of.
55, 64, 2002, all Supreme Court judgments.
Milord Sangram Singh's last few paragraphs, I'll just show. If
Please.
your Lordship, Milord, so desires, otherwise I will not invite your Lordship, Milord. Lordship kindly sees, Milord, paragraph, Milord, 27 onwards. Rather 26 onwards, 26 to 30. And then, Milord.
For what proposition you are citing, Sangram Singh?
Milord, I am trying to show, Milord. Milord,
yes.
Milord, under order 17 rule 2. Milord, court has, Milord, two aspects to consider. Whether it will, Milord, proceed under order 9.
Order 17 rule 2, you have to cross the hurdle of order 9 rule 6(1)(a), because that is the adjourned hearing. Mr. Chakraborty.
Yes, Milord, then
I have
order 9 rule 6(1)(a).
Order 9
This
rule
judgment has taken care of.
Order 9 rule 6(1)(a), the expression hearing only refers to the first hearing.
Yes, first hearing it was not.
First,
subject to correction, it was not posted for first hearing.
Yes, after restoration. After restoration, it was the first hearing.
But before that, Milord, he has filed his written statement. Lordship, kindly see, Milord, the first hearing is mentioned in the summons. That so and so date is fixed for first hearing. You come and
please challenge this. I think it's better.
Milord, the other two judgments, Milord, your Lordship need not look into.
Because if I consider that, we will not have the grounds.
Milord, Lordship, kindly see, Milord, last occasion, Milord, I was not prepared because, Milord, that was not in the list. Probably, if I am not wrong, Milord, your Lordship passed an order, but it didn't appear. Then, Milord, Lordship
was in the list. Mr. Chakraborty, I have informed both of you. I asked you could have said on that date. It was in the list. Mr. Chakraborty, don't say it was not in the list. I directed the matter to appear in the list under the heading for orders. By mistake, yes, by mistake, it was appearing under the heading listed motion. Don't say it was not listed. Then it was the court's mistake for which it was not appearing under the heading for orders. I asked my officers to inform both of you. So you came, you could have said that you were not prepared. So Chakraborty, on that date, you made arguments. It's unfortunate. If you now say
your Lordship has kept your orders, your Lordship has not passed an order.
All right, all right.
Yes, for orders.
All right.
It is not that, Milord, your Lordship has recorded argument is closed.
No, all right. Yes, you make your submissions. I will consider this. আচ্ছা এটা দেখুন তো এটা অর্ডারটা বেরিয়ে গেল অলরাইট ইউ মেক ইউর সাবমিশন
গ্রেটফুল
আচ্ছা এটা পাঠিয়ে দিন তো
আর আমি যখন ঠিক করে যাব কি করে
এটা পাঠিয়ে দিন
আমরা দিয়ে দিচ্ছি
yes so you are first relying upon
Milord 2004 Milord Calcutta Milord
yes ফাইলটা দিন ফাইলটা আবার চলে গেল ওইটা মানে অর্ডারটা এ করে দিন yes which paragraph
Milord paragraph 11 onwards Milord the
now Mr. Chakraborty you are ready Mr. Rai are you ready if you are not ready please say frankly I can fix another date এটা বেরিয়ে যাচ্ছে এটা ঠিক করে করো yes
Your Lordship may kindly consider, Milord, paragraph 11 onwards.
Yes.
Milord, order 17, rule 2 and 3, Milord, was relied on.
Paragraph 11.
Lordship.
Yes.
My lord, 2 has been quoted, your lordship need not look into.
Yes.
Then, my lord, 3, my lord, when my lord court may proceed, my lord, when it is my lord fixed for something else, then my lord court may proceed, otherwise it is written. Then lordship kindly sees paragraph 12. It is better to read rule 3 first. In conjunction with the above rules, he placed before us order 9 rule 6(1)(a) and order 9 rule 7 of the CP code. 6 my lord, procedure when only plaintiff appears. 1. Where the plaintiff appears and the defendant does not appear. When a suit is called on for hearing, then A. When summons duly served, if it is not proved that the summons was duly served, the court may make an order that the suit be heard ex parte. Procedure where defendant appears on the day of adjourned hearing and assigns good cause for previous non-appearance. Lord, here, my lord, he has to appear on the adjourned hearing date. My lord, my humble submission is he didn't appear on the adjourned hearing date. He, my lord, appeared much, my lord, after that. At the time of, my lord, 1 year, 8 months, my lord, passed, then, my lord, he appeared. My lord, at the time of, my lord, when we submitted our written notes of argument.
Written notes of argument.
Yes.
So you will not make any submission after that.
No, my lord, my written notes of argument is, my lord, I will not distinguish, my lord, because, my lord, the commercial courts
Please
act.
elaborate on the expression hearing. Please elaborate.
My lord,
What does it
hearing.
mean the expression hearing?
Yes. Lord,
When
kindly
it
sees.
concludes. When the hearing concludes. Or
It is in Sangram Singh's case, my lord, I will be relying on, my lord, because I need not repeat again, my lord, because it is in the Sangram Singh's case. Now, lordship kindly sees, my lord, thereafter, my lord, where the court has adjourned the hearing of the suit ex parte and the defendant at or before such hearing appears and assigns good cause for his previous non-appearance, he may, upon such terms as the court directs, as to cost or otherwise, be heard in answer to the suit as if he had appeared on the date fixed for his appearance. Now, my lord, his arguments were based on the above rules. This is the ultimatum paragraph, my lord. We do not find from the above any compulsion on the court to fix a separate date for ex parte hearing. In case the defendant happens to be absent without cause on the date already fixed for hearing of the suit, no doubt the court can give another chance to the defendant and put this suit up specifically for an ex parte hearing when order 9 rule 7 will come into operation. But this is at the direct discretion of the court. Discretion, my lord, specifically mentioned, and not a matter of compulsion. As such, court here made no error in passing the ex parte judgment on the date fixed for passing of it without putting it up to a further date for delivery of ex parte judgment. The above Supreme Court case cited by so-and-so is also an authority for the proposition that it matters in matters of setting aside of ex parte decree, the first court has a wide discretion. When the appeal courts, my lord, this is not required, my lord, for my purpose, my lord. Appellate court, my lord, cannot, my lord.
yes.
My lord, this is my first judgment. Now, lordship kindly see.
Sangram Singh.
Yes.
Yes.
My lord, this is reported at, my lord, AI 1955 Supreme Court, page 425.
Yes. Which paragraphs?
My lord, paragraph 26. My lord, I will not take your lordship's much time. My lord, I'll just, my lord, indicate the relevant.
Mr. Chakraborty,
My lord,
question of taking time, you can place in your own way.
My lord, I'm grateful. Lordship kindly sees paragraph 26.
Yes.
My lord, much before that, my lord, paragraph 25.
Yes.
In our opinion, Wallace J. and the other judges who adopt the same line of thought are right. As we have already observed, our laws of procedure are based on the principle that as far as possible, no proceeding in a court of law should be conducted to the detriment of a person in his absence. There are course exceptions, and this is one of the one of them. When the defendant has been served and has been afforded an opportunity of hearing, then if he does not appear, the court may proceed in his absence. But be it noted, the court is not directed to make an ex parte order. Of course, the fact that it is proceeding ex parte will be recorded in the minutes of the proceedings, but that is merely a statement of the fact and is not an order made against the defendant in the sense of ex parte decree or any other ex parte order, which the court is authorized to make. Lordship, my lord, kindly takes note of this. All that Rule 61A does is to remove a bar and no more. It merely authorizes the court to do that. What it could not have done without this authority, namely, to proceed in absence of one of the parties. The contrast in language between Rule 7 and Rule 10 emphasizes this. Now, as we have seen, the first hearing is either for the settlement of issues or final hearing. If it is only for the settlement of issues, then the court cannot pass an ex parte decree on that date because of the provisions to Rule 15, Order 15, Rule 3,
So
1.
pausing here for a moment, what was the date fixed for first hearing? For what?
Milord, when Milord, the summon was served on them.
On this 26.
Yes,
Paragraph
Milord, I need to
26
check
says-
the.
Paragraph 26 says, the first hearing is either for the settlement of issues or for final hearing. Show me what was the date of first hearing and what was it for?
Milord, it is either or. Milord, settlement of
So
issues.
show me, it must be either of. Show me from your facts for which, what was the first date of hearing and for what?
Milord, to some extent, Milord, issues were not framed. Milord, I must be candid. This is a procedural error.
Were not framed. Yes, the other thing is for final hearing. Show me that.
Milord, 22nd of January, if your lordship kindly sees, 22nd of January. No, that was the
January, 22nd of January.
It's the final, it's the first hearing. So Order 9 Rule 6(1)(a) deals with first hearing.
Yes.
So first hearing has to be either settlement of issues or for final hearing. So show me what is the date of first hearing and what for?
Milord, lordship kindly sees, Milord, 22nd of January.
Yes.
No, এটা তো পরে, এটা তো পোস্টে, এটা না এটা। Milord, the first hearing, Milord, Milord, so far as my
What is
understanding
according
goes.
to you the date of first hearing?
Milord, lordship once again, Milord, comes back, Milord, to order dated, Milord.
Yes.
Milord, the case management hearing was fixed, Milord.
Which order do you want me to see? Which is the date of first hearing?
Milord, lordship kindly first look into, Milord, 19th of November 2022's order.
19th of November 2022. Yes. Yes.
Plaintiff files written statement to the counterclaim filed by the defendant along with statement of truth, copy served and objected to. So, Milord, on this date, Milord, plaintiff filed, Milord, written statement to my counterclaim. So, Milord, there must be something, Milord, which, Milord.
Don't assume. Show me.
Then, Milord, lordship kindly.
There must be something. Don't say so. Show from the
lordship
record.
kindly see.
What is there?
Yes, Milord, lordship kindly see just before that, Milord, 29th
Because
of September.
Mr. Chakravarti, your counterclaim was accepted on 16th of December 2022.
16th of December, Milord?
2022.
Yes. 16th of December, Milord, I'm grateful. It appears from the record.
Yes.
But lordship kindly sees, summons was received by the defendant on 4th
And
of
when
March.
the case was restored?
Well, that case was restored on 16th of May, Milord, 2023.
Yes. So your counterclaim was accepted on 16th of December. So now 16th of May 2023, it was restored because it was dismissed on 12th of May.
But Milord, before that,
16th of May, it was restored. Now,
lordship kindly sees, Milord, 13th of March order, 13th of March 2023.
now
Milord,
kindly come to the order dated 3rd of July 2023.
yes, IA3, Milord, in respect of IA3 of 2022. Milord, today is fixed for fixing case management hearing in respect of IA number 3 of 2022. Defendant files Hajira on bare perusal of the records. It appears that the sufficient requisite court fees upon so and so has not been filed. As such, it requires further verification regarding court fees. For verification of the above extent, Milord, it was fixed. DA is directed to do the needful. Both parties are to act on the basis of downloaded copy of the order sheet so and so.
Yes.
Then, Milord,
Date of first hearing.
Lordship kindly sees Milord 10th of August order.
Yes.
2023 Milord, order number 24.
Yes.
Milord, we filed Milord deficit court fee.
Yes. So only on 10th of August your counterclaim was in form. Prior to that, it was not in form. So no date could not have been fixed prior to that.
Milord, assuming for a moment, Milord,
What
in case,
assuming?
Milord, in case,
Can a date be fixed prior to that?
Milord, we have seen, Milord, in
The
case of
counterclaim is ready for hearing, final hearing.
for hearing, but
Then-
Milord, may I just ask?
Says hearing.
In case of deficit court fee, Milord, it can be, Milord, there are judgments. I can come back, Milord, with the judgment if your lordship so.
No coming.
Milord, it can be
Coming
filed
back today.
Milord,
So,
it can be filed, Milord, even
what
before
is the
passing of
date?
judgment.
Mr. Chakraborty, what is the date according to you, which is the date of first hearing?
Milord, first hearing, Milord,
Please give me the
Milord,
specific date of first hearing.
Milord, my humble submission is, lordship kindly see, Milord, where, Milord,
Because you are relying upon paragraph 26 of Sangram Singh.
lordship kindly
says-
sees order 5.
And order 6 also says to the hearing, and it has been decided in Sangram Singh what is the effect of hearing. It says first
It
hearing.
says first hearing or final hearing.
Yes. So let us come to first hearing first.
Lordship kindly see,
Thereafter
Milord,
final hearing.
order 5. Milord, order 5. Milord, Sangram Singh has taken care of order 5. Milord, order 5 rule. Sangram Singh টা কোথায় গেল? এই 2003 টা দাও তো এখানে 2003 টা দেখো Lordship kindly see order 5 rule 1 Milord.
Yes.
Milord, summons Milord. Lordship kindly see when a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim and to file written statement of his defense, if any, within 30 days from the date of service of summons on that defendant, provided that no such summons shall be issued when a defendant has appeared at the presentation of the plaint and admitted the plaintiff's claim. Provided further that when the defendant fails to file the written statement, Milord, it is not required. Milord, summons substance of this that, Milord, if he appears, Milord, the date, Milord, is to be reckoned from the date of his appearance. Milord, here.
For what?
Milord, for service of summons.
Service of summons.
The service of summons, Milord, mentions the next date, Milord, fixed for what? Milord, here, Milord, we need to, Milord, look into, because I do not have the copy of the summons. Milord, what is mentioned therein? Because he, Milord, admitted position is that he appeared. Milord, he must have appeared after receiving a summons. Then, Milord, Lordship kindly sees, your Lordship is, Milord, putting a question, Milord, with regard to, Milord, the service of summons in counterclaim. Milord, the counterclaim, your Lordship will find from the order itself, they, Milord, out of their own accord, Milord, file written statement to our counterclaim. So, Milord, the date started, Milord, from the date of knowledge of the suit. 15 matters were running under the same heading, under the same number. So, Milord, there is no dispute or quarrel, Milord, that the counterclaim as well as, Milord, the suit was running, Milord, analogously.
Yes.
Now, Milord, be that as it may, Milord, it is a cross suit. Milord, I am not going into, Milord, all the provisions and hurdles I have to cross. Milord, Lordship kindly see, Milord, I do not find any order, Milord, from which I can show, Milord, the issues were framed. Your Lordship is, Milord, absolutely correct, I bow down. But Lordship kindly see, so what is the other procedures are concerned, it has been followed. The list of witnesses, not the documents, discovery, everything will follow day after. Now, Lordship, they didn't appear on the first date of hearing. Now, they even did not appear on the next adjourned. Now, they are seen
After you file your written notes.
Yes. Now, they have crossed the opportunity which they can avail under Order 9.7.
You Order 9 Rule 7 is not maintainable.
Yes.
In view of Himachal Pradesh judgment. Yes, that's
in view of Sangram Singh also.
Yes.
I'll read the Sangram Singh thereafter.
Yes.
Lordship kindly sees
Just the paragraphs which you are relying upon. Paragraph 26, we are on paragraph 26.
Yes.
You can proceed.
26 now as we have seen the first hearing in either of the settlement of issues or for final hearing. If it is only for the settlement of issues, then the court cannot pass an ex parte decree. Here decree has not been passed on that date because of the proviso to Order 15 Rule 3.1, which provides that can only be done when the parties or the pleaders are present and none of them objects. On the other hand, it is for the final hearing, an ex parte decree can be passed if it is passed under Order 9 Rule 13. Your Lordship need not look into. Now, Lordship kindly see, no order is contemplated by the court and therefore.
Which paragraph you are placing?
Paragraph 26, just after that, the very next page of paragraph 26.
Yes. Yes.
The middle of it,
Yes.
No order is contemplated. Your Lordship has got, last 4 lines of paragraph 26.
Yes, yes. No order is contemplated.
No order is contemplated by the court and therefore no order to set aside the order is contemplated either. But a decree is a command or the order of the court and so can only be set aside by another order made and recorded with due formality. Then comes Rule 7, which provides that if at an adjourned hearing the defendant appears, here on the adjourned hearing defendant didn't appear and shows good cause for his previous non-appearance, he can be heard in answer to the suit. His good cause showing only arises if he appears on the date adjourned. He didn't. As if he had appeared on the date fixed for his appearance. This cannot be read to mean, as it has been by some learned judges, that he cannot be allowed to appear at all if he does not show good cause. All it means is that he cannot be relegated to the position he would have occupied if he had appeared. We turn next to the adjourned hearing. This is dealt with in Order 17 Rule 1, Sub-Rule 1. Empowers the court to adjourn the hearing and whenever it does so, it must fix a day for the further hearing of the suit. Except that once the hearing of the evidence has begun, it must go on from the day to day till all the witnesses in attendance have been examined, unless the court considers, for reasons to be recorded in writing, that a further adjournment is necessary. Then follows Rule 2, where on any day to which the hearing of the suit is adjourned, the parties or any of them fail to appear. Any of them fails to appear here. The court may proceed to dispose of the suit in one of the modes directed in their behalf by Order 9 or make such other order as it thinks fit. Here I am. Court has both the powers. It is either or. Now, Rule 2 only applies when one or both the parties do not appear on the next date fixed for the adjourned hearing. In that event, the court is thrown back to Order 9 with the additional power to make such order as it thinks fit. When it goes back to Order 9, it finds that it is again empowered to proceed ex parte on the adjourned hearing in the same way as it did or could have done if one or other of the parties had not appeared at the first hearing. That is to say, the right to proceed ex parte is a right which accrues from day to day, because at each adjourned hearing of the court is thrown back to Order 9 Rule 6. It is not a mortgaging of the future, but only applies to the particular hearing at which a party was afforded the chance to appear and did not avail himself of it. Therefore, if a party does appear on the day to which the hearing of the suit is adjourned, he cannot be stopped from participating in the proceedings simply because he did not appear on the first day or some other hearing. But though he has the right to appear at an adjourned hearing, he has no right to set back the hands of the clock. Order 9 Rule 7 makes that clear. Therefore, unless he can show good cause, he must accept all that has gone before and be content to proceed from the stage at which he comes in. But what exactly does that import? To determine that, it will be necessary to hark back to the first hearing. We have already seen that when a summons is served to the defendant, it must state whether the hearing is for the settlement of the issues only or for the final disposal of the suit. Order 5, Rule 5. In either event, Order 8, Rule 1 comes into play, and if the defendant does not present a written statement of his defense, the court can insist that he shall, and if on being required to do so, he fails to comply. The court may pronounce judgment against him or make such order in relation to the suit as it thinks fit. Lord, Order 8, Rule 10 need not be looked into. It is not applicable here. This invests the court with the widest possible discretion and enables it to see that justice is done to both sides, and also to witnesses if they are present, a matter on which we shall dwell later. We have seen that if the defendant does not appear at the first hearing, the court can proceed ex parte, which means that it can proceed without a written statement. And Order 9, Rule 7 makes it clear that unless good cause is shown, the defendant cannot be relegated to the position that he would have occupied if he had appeared. That means that he cannot put in a written statement unless he is allowed to do so. And if the case is one in which the court considers a written statement should have been put in, the consequences entailed by Order 8, Rule 10 must be suffered. What those consequences should be in a given case is for the court, in the exercise of its judicial discretion, to determine. No hard and fast rule can be laid down. In some cases, an order awarding cost to the plaintiff would meet the ends of justice. An adjournment can be granted or a written statement can be considered on the spot the issues framed. In other cases, the ends of justice may call for more drastic action. Now, when we speak of the ends of justice, we mean justice not only to the defendant and to the other side, but also to the witnesses and others who may be inconvenienced. It is an unfortunate fact that the convenience of the witness is ordinarily lost sight of in this class of case, and yet he is the one of the deserves the greatest consideration. As a rule, he is not particularly interested in the dispute, but he is vitally interested in his own affairs, which he is compelled to abandon because a court orders him to come to the assistance of one or other of the parties to a dispute. His own business has to suffer. He may have to leave his family and his affairs for days on end. He is usually out of pocket. Often he is a poor man living in out of way village and may have to trudge many very miles on the feet. And when he gets there, there are no arrangements for him. He is not given accommodation when he reaches the court. In most places, there is no room in which he can wait. He has to loiter about in veranda or other under the trees, shivering in cold of winter and exposed to the heat or summer, wet and miserable in the rains. And then after wasting hours and sometimes days for the turn, he is brusquely told that he must go back and come again another day. Justice strongly demands that this unfortunate section of general public compelled to discharge public duties, usually at loss and inconvenience to themselves, should not be ignored in the overall picture of what will be best served for the ends of justice. And it may well be a sound exercise of discretion in a given case to refuse an adjournment and permit the plaintiff to examine the witnesses present and not allow the defendant to cross-examine them, still less to adduce his own evidence. It all depends on the particular case. But broadly speaking, after all the various factors have been taken into consideration, carefully weighed, the endeavor should be to avoid snap decisions and to afford litigants a real opportunity of fighting out their cases fairly and squarely. Cost will be adequate compensation in many cases, and in others, the court has almost unlimited discretion about the terms it can impose, provided always the discretion is judicially exercised and is not arbitrary. Then, Milord, 34, Milord, in the Code of 1859, there was a provision, section 119, which is said, Milord, it is not required. Lordship kindly sees thereafter. Milord, paragraph 35. Milord, just Milord, paragraph 34, Milord, thereafter, Milord, I'll just, Milord, from the last paragraph, the general rule founded on principles of natural justice that proceedings in a court of justice should not be conducted behind the back of a party in the absence of an express provision to that effect is no less compelling. But that apart, it would be anonymous to hold that the efficacy of the so-called ex parte order expends itself in the first court, and that thereafter a defendant can be allowed to appear in the appellate court and can be heard and can be permitted to urge in that court the very matters he is shut out from urging in the trial court. And in the event that appellate court considers a remand necessary, he can be permitted to do the very things he was precluded from doing in the first instance without getting the ex parte order or set aside under Order 9 Rule 7. Now, this is not a case in which defendant with whom we are concerned did not appear in the first hearing. Now, my lord, the cases, my lord, concerned cases were discussed, and my lord, may I just read further, my lord. The first hearing was on 11th of December 1952 at Kota. The appellant appeared through counsel and filed a written statement. Issues were framed and case was adjourned till so-and-so date for the petitioner's evidence alone from so-and-so to so-and-so date. Therefore, Order 9, Rule 6 and 7 do not apply in terms, but we have been obliged to examine the order at length because of the differing views taken in the various high courts, and because the contentions is that Order 17, Rule 2 throws one back to the position under Order 9, Rule 6 and 7. And there, according to one set of views, the position is that once the ex parte order is passed against the defendant, he cannot take further part in the proceedings unless he gets that order set aside by showing good cause under Rule 7. But that is by no means the case. If the defendant does not appear at the adjourned hearing, irrespective of whether or not he appeared at the first hearing, Order 17 Rule 2 applies, and the court is given the widest possible discretion either to dispose of the suit in one of the modes directed in that behalf by Order 9 or make such order as it thinks fit. The point is this: the court has a discretion which it must exercise. Its hands are not tied by the so-called ex parte order, and if it thinks they are tied by Order 9 Rule 7, then it is not exercising the discretion which the law says it should, and in a given case, interference may be called for. My lord, here, my lord, this is very important. My lord, Order 9 Rule 7 will not act as an embargo, my lord, upon the court, my lord, to proceed further. My lord, the Supreme Court is of the clear view. Now, my lord, the Lucknow bench, my lord, the full court bench, that was, my lord, relied on, and my lord, the decision taken by the Lucknow bench was, my lord, is not good, hold good, my lord, that is the exact, my lord, finding. Now, lordship may kindly skip over to 38, my lord. Yes. A much weightier consideration is that the plaintiff may be gravely prejudiced in a given case because, as the learned Rajasthan judges point out, and O. Sullivan J. thought, when a case proceeds ex parte, the plaintiff does not adduce as much evidence as he would have if it has been contested. He contests himself with leading just enough to establish a prima facie case. Therefore, if he is suddenly confronted with a contest after he has closed his case and the defendant then comes forward with an army of witnesses, he would be taken by surprise and gravely prejudiced. No, this is also another aspect my lord dealt with. My lord, matter was running ex parte. My lord, in order to prove my prima facie case, my lord, I have submitted only one witness. Now, my lord, they will appear and suddenly, my lord, they will contest with list of witnesses. My lord, that will prejudice to my lord case, because my lord, I have already closed my my lord witnesses and all. That objection is, however, easily made by the wide discretion that is vested in the court. If it has reason to believe that the defendant has by his conduct misled the plaintiff into doing that these learned judges apprehend, then it might be a sound exercise of discretion to shut out cross-examination and the adduction of evidence on the defendant's part, and to allow him only to argue at the stage when arguments are heard. On the other hand, cases may occur when the plaintiff is not and ought not to be misled. If the considerations are to weigh, then surely the sounder rule is to leave the court with an unfettered discretion so that it can take every circumstances into consideration, and do that seems best suited to meet the ends of justice in the case before it. So, my lord, my humble submission, my lord, it is ample, my lord, discretion on the part of the court to consider and proceed. my lord, if they fails to appear on the repeated occasions, my lord, court has proceeded. Court has no other alternate option because my lord, order number rule 7 would not proceed further because they have lost, my lord, the stage of order number rule 6(1)(a). Now, Lordship, my lord, the ultimatum paragraph is, my lord, in the present case, we are satisfied that the tribunal did not exercise its discretion because it considered that it had not, my lord, it is not required, my lord, I am not reading.
Yes.
And my lord, the third judgment, Lordship kindly sees, my lord, so far as your Lordship's, my lord, jurisdiction. Lordship kindly sees, my lord, 2025 SCC online SC, my lord, page 985. My lord, taking my worst case, my lord, that, my lord, court, my lord, there is a mistake on the part of the court. My lord, they have to come up before the court itself, my lord, explaining, my lord, the reasons for the appearance.
Which paragraph of this judgment you are relying upon?
My lord, paragraph 6, my lord, onwards.
Yes.
The facts of the case almost speak for themselves. A search was made for the application on which the order of the court directing a deposit of so-and-so was to be passed. That application remained unpressed, though the district judge adjourned the case more than once. It is, however, quite clear that the challan was prepared under the court's direction and the duplicate challan prepared by this court as well as one presented to the bank have been produced in this case and they show the lesser amount. The challan is admittedly prepared by the execution clerk and it is also an admitted fact that so-and-so is an illiterate person. The execution clerk has deposed to the procedure which is usually followed and he has pointed out that first there is a report by the so-and-so about the amount in deposit. Then Lordship kindly skip over. This is, my lord, there is no higher principle for the guidance of the court. You know, the last few lines of paragraph 6 I am reading. There is no higher principle for the guidance of the court.
Which paragraph?
Paragraph 6, last few lines, my lord, about 5 lines.
Paragraph
There
6. Paragraph 6 is only 3 lines is there.
My lord, your lordship is
2025
giving...
SCC online SC.
No. Lord, I'm sorry.
So you said you will also be relying upon this. You can complete this. We are handed up this to 2025 SCC online SC 985.
Lordship, kindly see paragraph 10.
Paragraph
9 and 10 first.
9 and 10.
Yes, my lord, the essence of the power under Article 227 being supervisory.
Yes.
It cannot be invoked to usurp the original jurisdiction of the court, which it seeks to supervise. Nor can it be invoked to supplant a statutory legal remedy under the Civil Procedure Code. For example, existence of appellate remedy under Section 96 of the Code operates
How
as
this judgment is relevant in this case?
Lord, here, my lord, they, if at all, my lord, they want to explain, my lord, their conduct. Lordship kindly sees, my lord, their application for a moment. My lord, in respect of which day, give the explanation. Lordship kindly see, my lord, their explanation.
Mr. Chakraborty,
Lord, they, my lord,
this judgment is on a different footing altogether. Here it says that if, while deciding ancillary matter, the High Court rejects the plaint, it says under 227. 227 is in this matter not a challenge against an order under Order 7, Rule 11. There may be cases. You have filed an application under Order 7, Rule 11, let us assume. That has been rejected. So, does it mean, this judgment means you cannot challenge under Article?
No. No.
So, let us assume, now you are challenging an interlocutory order. Let us assume Order 6, Rule 70. Now, you are coming up and the court under Article 227 says, your plaint, I am rejecting your plaint. This is a case of that nature.
No,
it says, under 227, you cannot reject that because when you are rejecting the plaint, it's a deemed decree, it's an appeal, forum will be lost. That's the judgment which is this?
My lord, taking your lordship's, my lord, observation. Lordship kindly sees. Your lordship, my lord, I bound
I
to.
think subject to correction, that is the
My lord,
observation.
here,
of this.
my lord, here what happened? My lord, they filed an application, my lord, praying for setting aside of ex parte order. Lordship kindly see their prayer for a moment. My lord, what they have sought for.
They have paid for setting aside of the ex parte order.
No, Lordship kindly have a look.
Less
Lord,
that.
Lordship kindly sees, my lord, their application. Application page টা বলো তো?
Page.
My lord, I'll just note. Yes, page 168. My lord, I'll take your lordship straightway to the pair, and then, my lord, I'll come back, my lord, to the application itself. My lordship
There
kindly
is on
sees.
page 173,
Yes.
set aside or vacating the order of ex parte hearing of the counterclaim. That's just simple prayer.
Yes, now, my lord, so far as your lordship has seen, my lord, ex parte hearing, my lord, no date was fixed. My lord, if my take, my lord, my worst
So
case.
according to you, order 9, rule 7 was not maintainable. Pure and simple.
Yes, so, my lord, there is, my lord, application for vacating in the eye of law, my lord, before the learned trial judge. Now, my lord, your lordship is, my lord, I'm just, my lord, I do not know, my lord, what is your lordship has already, my lord.
I've not, since you have, now I am in open mind.
Lordship may kindly.
Since
My
I
lord,
am
if your
hearing both of you,
my lord,
I'm
in
in
case,
open
my
mind.
lord, in case your lordship passes an order, my lord, relegate, my lord, the parties back, my lord, to the position where, my lord, at the stage of framing of issues. My lord, then what would happen? My lord, then, my lord, without any application, your lordship is exercising power under Article 227. My lord, then, my lord, the purpose of, my lord, this, my lord, showing judgment is that, my lord, without any application, your lordship is, my lord, granting their prayer, my lord, at my, my lord, revisional application. My lord, which, my lord, the Honorable Supreme Court, in respect of all the, my lord, Order 7 will court, my lord, out of, my lord, its own jurisdiction 227 exercise and, my lord, set aside the plain. My lord, here, my lord, the similar case here. Although, my lord, here, my lord, they have to, my lord, first take out an application. My lord, showing, my lord, the date of first hearing. Even if, my lord, it is not posted for first hearing, they have to show, my lord, on the adjourned date, my lord, what is their conduct. Each and every adjourned date, my lord, lordship kindly sees how many dates were fixed thereafter. My lord, they have, my lord, almost a span of 180, my lord, 1 year, 8 months. Now, my lord, they are trying to, my lord, relegate back, and lordship kindly sees the application for a moment. My lord, just, my lord, one, my lord, paragraph, my lord, I'll show. Paragraph 5, lordship kindly sees. My lord, their explanation is regard at page 170. My lord, their explanation is with regard to, my lord, 3 dates: 10th of May, 11th of May, and 12th of May. Now, lordship kindly comes back, my lord, what happened, my lord, on these 3 dates.
That's prior to
even, my lord, rejection. My lord, 10th of May, if I'm not wrong.
Follow you after restoration, no explanation.
Nothing.
After,
Nothing.
accepted. Yes.
Now, my lord, your lordship kindly sees, my lord, in such a situation, my lord, their only recourse is should have come to a conclusion, since your prayer is contrary to your statements and explanation. It is not maintainable at all, because, my lord, the court should come to a conclusion that either first date of hearing or with regard to the adjourned date of hearing, court has no other option. Yes, they are able to satisfy that first date of hearing, then, my lord, good cause has to be provided. And, my lord, if the good cause is satisfactory, my lord, they are relegated back, my lord, to the first date of hearing.
On facts, they have failed to satisfy good cause test.
My lord, not only that, my lord, they are, my lord, they have not make any satisfactory application in the eye of law, my lord.
That failed to make out any good cause as contemplated under Order 9, Rule 7.
Now, your lordship kindly sees the order impugned for a moment. My lord, the order impugned is, my lord, is not speaking order. Not only that, lordship kindly sees the order impugned only says that they are allowed to contest. My lord, the only allowing to contest, my lord, without specifying at what stage, my lord, makes it, my lord, the order, my lord, null and void. Because my lord, court has not come to a conclusion whether they will be participating in the suit by way of cross-examination, or by way of participation from the date it is fixed, or it will be relegated back to the stage where the initial issues of hearing. Court has not clarified that. To that extent, it is perverse order. And now, at my application,
that if your submission is accepted, now what's the relief which you are entitled to?
Now,
it is a perverse order, but no reasons have been assigned. What should be done?
Your lordship,
the application should be rejected,
your
or it
lordship,
should be restored.
your lordship, may.
Please make submissions on
Your
that.
lordship may. Either.
I'm asking you, what should be done? What should be the
Yes,
idea?
in that case, although I should not, this, since your lordship's query is this, either your lordship may remand the matter back, for after hearing. In that case also, submission. Why? The application itself, is not maintainable in the eye of law.
Mr. Chakraborty, that can be rejected.
Yes.
That can be rejected after remand. That
Or, your lordship can, set aside the order prima facie.
I will be violating this 2025. I will not, cannot go into that.
Rule 25 of,
No. This 2025 Supreme Court judge.
2025.
I cannot for the first time do that.
Then lordship kindly demands it back.
Yes. Any other thing, Mr. Chakraborty? What are the other decisions?
They should not be given an opportunity on my application without making an appropriate application to the court below.
Mr. Chakraborty, you are saying that it's a perverse order. No reasons have been assigned. They have been allowed to contest without indicating from what stage. That's the sum and substance of your argument. And according to you also, it's an unreasoned order. So if it is, it has to be set aside. Now, what other things? Set aside without deciding?
No.
Or
no.
So it has to be remanded for a fresh.
That is my submission, Olav.
And any other decision you want to submit?
No, Milord, I do not want to.
You want to submit any other decision, 2002 Supreme Court or something else you want?
Milord, there is another judgment. I need not pardon it. Milord, that is not required. If your lordship, Milord, I am able.
Whether it applies? Yes, please.
No, Milord,
please.
Unnecessary, Milord, wastage of time, Milord.
What point? On what proposition?
Milord, there was, Milord, the Madras High Court, Milord, which, Milord, I was just trying to rely on. Milord, that judgment, Milord, what was happened, Milord, it was a mistake on the part of the court. Milord, court, Milord, fixed, Milord, court fixed the.
Show me that judgment.
Milord, lordship kindly hears it, your lordship feels it necessary, I will place. Milord, Madras High Court, Milord, there, Milord, before the learned court, Milord, date was fixed. Milord, the Sheriff Sadar, what he did, Milord, he, Milord, mentioned the wrong date. Now, Milord, the party, Milord, on the very date, Milord, didn't appear at all. And Milord took the plea that since there is a wrong posting in the register, so you cannot make it dismissed for default. So Milord, the court, Milord, come to a conclusion, although there was a wrong, Milord, mentioning of date, but since you have not appeared, you failed to appear on that date because it is not the duty of the court to intimate you the next date when you are appearing. So when you are appearing, it is your duty to follow up, Milord, the next date of hearing. So in this case,
up to you whether you want to rely upon that or not.
No, Milord, I do not want to.
Anything more, Mr. Chakraborty?
No, Milord, this is all.
Yes, Mr. Rai, anything in reply? What is your answer to Sangram Singh?
It's not applicable.
Why?
If your lordship only takes up the order dated 13th March 2023.
of March
2020, order number 16.
Yes. Yes.
This is the date fixed for the purpose of hearing of the order 13 rule 1 and 2 application. And filing of written notes argument by the plaintiff and illustrator order 13 rule 1 and 2.
This is prior to restoration.
Prior to restoration.
Yes.
Now, my lord, can you turn to 11/5/2023. So cause regarding the injunction application, my lord, got it.
11.
19.
Yes.
This is the so cause in respect of injunction application.
Yes.
And next date 12/5/2023 for so cause in respect of the suit.
Yes.
And it was dismissed on 12/5/2023. Money suit number 12 of 2022. Pause there for a moment. And when the deficit court fees, because Court Fees Act Section 3 will come to your lordship, when the date of presentation of the plaint will come, Section 3 of the Court Fees Act. Now, my lord, if your lordship can consider, along with this set up put up petition, one application also been filed for
which order?
Order number 21 dated 16/5/2023.
Yes.
Restoration, order of restoration.
Yes.
So now it has been treated as a suit independent to the suit filed by the plaintiff. Now one can take the order 9, rule 9, sub rule 2.
Order 9.
Rule 9, sub rule 2. Because it was them who were precluded to file a separate suit on the ground for dismissal, because both are standing on the same footing. Am I clear to your lordship? Counterclaim and the plaint.
Yes.
So their counterclaim also dismissed for default. So for restoration of the same, it comes within the either order 9 rule 8 or order 9 rule 9. Then order 9 rule 9, can you consider order 9 rule 9 sub rule 2?
Yes. But Mr. Rai, you have not challenged that order.
No,
You have not challenged that order. I have also made a specific finding. So you have not challenged that order. So unless you have challenged that order, you cannot say that the order is wrong. Without challenging that order, how can you say that?
If something, my lord, it is the 227.
Mr. Rai, you have not challenged that.
Even
and your application will show that you have accepted that position. You want yourself to contest to vacate the ex parte order.
Now my lord, the next.
You have not challenged this order.
I am following what is following from your lordship, that I'll come. Next order, your lordship find 3/7/2023.
3/7.
2023.
Yes.
On bare perusal of records, it appears the sufficient requisite court fees upon written statement come counterclaim application has not been filed by the defendant. Further verification regarding court fees. Pause here for a moment, and my lord, what is fallen from your lordship in the acceptance of court fee? That is 10/8/2023. What is the court fee paid? Defendant files evidence 1 for affidavit of acceptance of the written statement. Where is the adjudication regarding the deficit court fees in connection with the suit itself? Nothing.
No, next sentence say as per office report, record is verified and found.
Correct. Regarding deficit court fees.
So there is a finding. You have also not challenged this order.
So as of my lord is considered, because my lord 149, I'll come to 149. Enlargement of the time for
that is, Mr. Rai, you have not challenged that. Other things.
So what is the date? What is the date for hearing?
That according to Mr. Chakraborty is that summons was served, suit as well as the counterclaim was proceeding. You also filed your written statement to the counterclain. So
what is the date for hearing? What is the procedure to be adopted after registration of a suit?
No, according to him, Order 9 Rule 6 does not appear. No dates, because dates were there. And even if, according to him, Order 17, because it's a case of adjourned hearing. Order 17.
That is why it is not a case of hearing.
Or as the court may deem fit, he says the court is empowered to proceed.
No. Subject to question? No. And the judgment which is there about the factual is a different case. So, for verification, there is As such, record further verification regarding the court fee. Now, my can turn to this is the date according to court registration of the counterclaim. 10/8/2023, order number 24.
Yes, because court fees were found to be correct.
So this is the date for registration of the counterclaim.
And immediately for list of witness without any date for framing of issues.
Even if, my lord, after registration, what will be the course? If the suit to be registered on that date, because it cannot go automatically, because 30 days is the date for that. I'll satisfy your lordship.
But Mr. Rai,
No, my lord, subject to
in that case, you have filed your written statement.
Yes, I have filed, but it does not preclude that. Is there anything established as a statute which is followed on the earlier occasion? A suit has been filed. Counterclaim should be filed within 30 days. I did not put in the requisite court fee within 30 days. Whether the limitation by resorting to the date of filing by taking 8 of 149 can be payment of the deficit.
So according to you, this is the date of registration of the counterclaim. It will start from this.
Yes. Then where is the procedure regarding service of summons? Because 30 days, under the statute, 30 days is the limitation for filing of the counterclaim.
And after this, no summons was also served.
I need not to go any other thing. The fixing the court for ex parte and other things comes later on. Where is the explanation after registration of the counterclaim in this form? Notice was given. That too after restoration.
Yes.
Even assuming, my lord, then kindly takes up the judgment which my learned friend relied upon vociferously, that 2003 Calcutta.
Yes.
This is reported in 2004 Calcutta, page 98.
Yes.
Kindly consider.
It says there is no necessity to fix a date for.
Prior to that, paragraph 8 and 9. My lord has to read the judgment on the basis of the facts itself.
Yes.
The case on merits accordingly is very weak. It is not existence for the appellants. Mr. Banerjee has two technical points. First, general suggestions and said, on this authority, when without determining which cause is sufficient, the court have no focus to his attention on the date of non-appearance. Other earlier dates did not have a bearing on this matter. In our case, consider, in our case, however, the earlier dates were not isolated. The hearing, in fact, took place ex parte on last 2 dates earlier. As such, the reliance placed by the lower court on continued non-appearance with appearance is not an immaterial extraneous consideration. It is not.
So in your case also, hearing took place ex parte on various occasions.
Can you consider where is the ex parte hearing took place?
No. Mr. Chakraborty says there is no.
Where is the hearing took place?
Sangram Singh says there is no fixation, no necessity to fix a date. To pass an order fixing the date for ex parte hearing.
I am not on that.
Please kindly come to Sangram Singh.
Milord, only one Milord small Milord thing I just indicate because Mr. Roy might have missed this. Milord, we filed Milord that court fee of 50,000 entire in the year 2022. It is a wrong recording of the judge, language judge. Lordship kindly sees.
Mr. Chakraborty, you have not challenged that order. You have not challenged that order.
146.
You have not challenged that order. If I permit you, then I will also permit him to challenge the initial order of restoration. Without challenging, if you are permitted to make that, I will also permit him to challenge.
Your Lordship, please.
Yes.
But Milord, court fees was paid 146.
I cannot go by that because there is no recording.
Wrong recording.
It says wrong recording.
In my counter claim itself, Milord, I have mentioned I have paid.
You have not challenged that order, Mr. Chakraborty. You proceeded on that basis. Yes.
If your Lordship kindly takes up the order dated 3rd April
Please
2020.
come to, kindly come to.
After that, I place the order. After that, I
Order of what?
fixation of date for the purpose of hearing. Submission of report by landlord.
No, what are you placing?
The acceptance of the commissioner report. Page.
Which order? Which order?
Page order 32, 3rd April 2024.
Order number 32. Yes, order number 32.
The first date is, my lord, for acceptance of the commissioner report.
Submission of report. Yes.
Submission of report. Last date, my lord, 15/7/2024. Commissioner did not take steps.
No, no. Which order you are placing?
15/7/2024. After that.
After that. Yes.
Yes, there is no steps taken. So after that,
is fixed.
For hearing of the advocate commissioner's report.
For hearing of the advocate commissioner's report.
Commission steps takes no steps.
Yes.
So compliance of order 26 rule 10 sub rule A comes on 11/9/2024.
11/9/2024.
না করেছে কে বলেছে করিনি 11/9/2024 রিপোর্ট অ্যাকসেপ্ট হলো order 26 rule 10 sub rule A statutory compliance.
Yes.
So after that, filing of written notes argument by the defendant.
Yes.
So what is followed from a loss is the hearing.
No, Mr. Chakraborty says he has filed the written notes, hearing concluded. That's the submission of Mr. Chakraborty.
That is contrary. If there are rules, if you are logically considered, there are differences in rules in so much Civil Procedure Code and the Commercial Courts Act. When the amendment was there, it is that the hearing will take place after, before that.
He does not wish to make any submission. Can you compel him to make his submission?
Then there is no hearing at all in the eye of law.
Written notes is there.
That is why written notes to be filed before hearing. Well, that is the what I have specifically mentioned. So my learned friend can say that it does not require the hearing. On the basis of written notes, the order can be passed under the Commercial Courts Act. It is the submission. I failed to make myself clear. It is the argument of Mr. that without that compliance, because statutory compliance requires so much Civil Procedure Code after hearing, written notes of argument. Here, my lord, within 4 weeks before the hearing. So it is conjoined. My lord cannot isolate it both. That yes, I can separately file the written notes of argument and conducted the hearing. Because unless until I participated in the hearing.
Even if that case is accepted, you will be permitted to only argue.
That is why is the hearing. That is the why precisely.
Yes. So even if it is accepted that you have appeared on that date, so he will make arguments. He will make arguments.
That is why, my lord, that is
on the basis of the materials on record.
That is why, my lord, presupposely, what is the date for proceeding under Order 9, Rule 7 and 7(2). My lord, can you consider that way also?
Order 9.
Order 9, Rule 9, Sub Rule 2, I have drawn to your lordship attention. Now, my lord, can turn to Order 9, Rule 6.
Yes. Yes. Yes, Order 9, Rule 6.
A.
Yes, A.
If proved the summons was duly served, the court may make an order that the suit shall be heard ex parte. May. Now, kindly consider B. Where is the summons after registration of the counterclaim?
Yes.
So Therefore, my lord, if my lord goes in that way, then also after restoration, taking into aside everything, after restoration, contract claim registered on such and such date. After deficit payment of deficit court fees. After 30 days, so deficit court fee is not automatic by condoning the court condone. So it should register on that date. But is the summons after that? If there is no summons after that, then my lord, order 9 rule 6 sub rule B will come into play. Yes, we can order 9 rule 6 sub rule A. So it is not a day court A can order that the suit pay hard ex parte. Now, my lord, pause there for a moment and kindly consider the argument which was advanced. Order 17.
Yes. Yes.
Your lordship may kindly consider. On the day fixed for the hearing of the suit or any other day to which the hearing is adjourned, the party having the right to begin shall
Which order you are placing?
Order 9.
Order?
Order 17.
Rule?
Rule 2.
Yes.
In every case, such case, shall fix a date for the further hearing of the suit. Kindly pause there for a moment. This is not related to the first, whether the hearing has been started under the Code of Civil Procedure. What is the date of hearing? After completion of the evidence.
Order, Mr. Rai, order 17, rule 1, sub rule 2 is on a different thing altogether. Order 17, rule 1 is if on the prayer of a party it is adjourned.
Yes.
So, it's
not a case.
So now here, order 17, rule 2 may apply.
That is why. So order 17, rule 2 comes. In every such cases, the court shall fix a day for the further hearing of the suit.
No. That is, you are saying order 17, rule 1, sub rule 2.
No, my lord.
You are
Order 17, rule 2.
Rule 2 is procedure if parties fail to appear on the day fixed. You are reading order 17, rule 1, sub rule 2.
Yes, sub rule 2.
Sub rule 2 is a different thing altogether. If
Where
the parties,
date on which the hearing of the suit is adjourned.
Yes, at the instance of a party.
At the instance of the party.
It is not that case. Kindly come to order 17, rule order 17, rule 2.
Yes, my lord. Where on any day to which the hearing of the suit is adjourned, the parties or any of them fail to appear, the court may proceed to dispose of the suit in one of the modes directed in that behalf by order 9 or make such order at this thing split. Explanation, my lord Kali. Where the evidence or a substantial portion of the evidence of anybody has already been recorded and such party fails to appear on the date to which the hearing of the suit adjourned, the court may in its discretion proceed the case as the party
This is explanation is not applicable in your
this
case.
is the case now, my lord Kali. Consider order 9.
The Chakravarti says, so it says it may proceed on the modes under order 9 or may make further orders as these things fit. According to him, so court is not obliged to revert back to order 9. It can proceed. And in that regard, he is referring to kindly come to Shankar. Yes, paragraph 25. What is your answer to this? You have got a copy of Sangnam Singh?
Yes. When the defendant has been served and has been afforded an opportunity of appearing, then if he does not appear, the court may proceed in his absence. I am on that.
Thereafter, please proceed.
That ballot is kindly considered. Where the opportunity is granted and served with a valid summons. Everything starts there. But it is noted court is not directed to make an ex parte order. Of course, the fact that it is proceedings ex parte will be recorded in the minutes of the proceedings. But that is merely a statement of fact. and is not an order made against the defendant in the sense of an expert.
So it says no specific order is to be made, and that is also 2004 Calcutta.
2004 Calcutta, the hearing started.
Yes. But whether any order is to be recorded, 2004 Calcutta is also on.
Separate date not be fixed for hearing.
There is no, so the court can only say I am proceeding ex parte.
Yes.
But it should not have to record that to make an order that the suit shall proceed. Will proceed ex parte. It's not that.
Basis. Where is the service?
That is a different thing altogether.
That way also.
Service, Mr. Chakraborty has a different argument altogether. He says it's not necessary since you are appearing, you have filed your written statement. There is no necessity. It's a question of service of summons. So there was no necessity because summons.
Can you consider rule section 3 of the Court Fees Act when that suit? Can you consider?
Court Fees Act,
Court Fees Act. Order 8, 6A, order 8.
You have a copy of the Court Fees Act, Mr.
Before that, Malad, can you take some order 8?
Order 8.
3A.
Order 8.
Rule 3A. Huh? Oh.
Order 8 rule?
3A, that is for the commercial court purpose.
Oh, 3A, commercial court. Yes.
So these are the procedure to be content for the purpose of. No, that is High Court division, my lord. 6A is the defendant in a suit may, in addition to his right of pleadings. Well, got it?
Commercial division of the High Court.
After that, 6A.
Oh, 6A. No, 3A is inserted. 6A is
6A, my lord.
6A is counterclaim.
Counterclaim. That is why, my lord.
Oh.
A defendant in a suit, in addition to his right of pleading, set up a counter set up under Rule 6. By way of counterclaim against the claim of the plaintiff, any right claim related to the cause of action that was there before or after defendant delivered his defense, or before the time limited for delivery of defense. I expect when such counterclaim is in nature of a claim for damages or not, provided such counterclaim shall not exceed the pecuniary jurisdiction. So, my lord, if your lordship can consider delivered defense before the time limited for delivery of defense or has expired, where such counterclaim is in nature of the claim for damages or not. Such counterclaim has the same effect when it is a liberty to file a statement. Now, pause there for a moment. What is the date for delivery of the defense?
Delivery of defense, Mr. Rai, in this case, defense was delivered prior to that. So it was already there.
No.
So
then, my lord, delivery of defense after the time expired, this was regularized. My lord, can you consider it is the court fees? What is the date for presentation of?
Mr. Rai, even if that submission is accepted, do you mean to say you have to file another fresh written statement?
No. Along with the court fees. That is why I have when
your written statement is already there. So when your written statement,
I am on their counterclaim.
No. Counterclaim, yes. I follow your argument that unless the court fee is paid in full, there cannot be any registration of the counterclaim.
There cannot be. So therefore, whether this counterclaim can be accepted or not, that is something else. So that rate of registration is mandatory for the purpose of crossing the order hurdles, order 8, rule 9, order 8,
you can,
order 9.
That submission you can make if you are permitted to advance argument, because to that extent, I think Mr. Chakraborty is not disputing. You can appear on that date, advance your argument. So on their counterclaim, you can make their make arguments.
That is why, my lord, what
Sangram
Singh said, my lord, if you logically consider, what Sangram Singh said, if you logically consider, there are of course exceptions, and this is one of them. When the defendant has been served.
From where are you placing?
That paragraph 25, which is
25. Yes, kindly come to paragraph 25. Yes. Yes, yes.
There are of course exceptions. No proceedings in the court should be conducted to detriment of a person in his absence. My lord,
Yes, yes.
you are the same. When the defendant has been served and has been offered an opportunity for appearing, then if he does not appear, the court may proceed in his absence. But be it noted, the court is not directed to make an ex parte order. Of course, the fact that it is proceeding ex parte with the recorded in the minutes for its proceedings, but that may is merely a statement of fact and not an order made against the defendant in the sense of ex parte degree or other ex parte order, which the court is authorized to make. All that Rule 61A does it to remove a bar and no more. It merely authorizes the court to do that which it could not have been done without this authority, namely to proceed with an absence of the one of the parties.
So, Mr. Rai, in paragraph 25, it says, even without directing that the court shall, passing an order that the court shall proceed ex parte,
Ex parte, it is
court can
there.
proceed ex parte.
It is there. It is here. It does not say that court cannot pass. Even in the statute also does not say that
You agree to that?
court can proceed.
Without, no. Without an order also court can proceed.
Court indicating that court will, the proceedings has been posted for ex parte hearing.
Order 9 Rule 61A. What is your submission? Whether there is any requirement to make an order that the court will proceed ex parte, or the court on its own on a particular day can say, yes, I am proceeding ex parte. What is your submission on that? Mr.
So,
Chakraborty says there is no necessity to record an order. What is your submission on that? Paragraph 25 also says so.
And paragraph 26 also.
Yes.
Can you consider? Now, as we have seen, the first hearing is either for the settlement of issues.
No, that is a different thing, Mr. Rai. I am on a proposition that whether the court has to record an order that will proceed ex parte, or can on its own proceed ex parte. Mr. Chakraborty says
proceed ex parte, that is
we are accepting that proposition.
I'll argue on that aspect, my lord. I'll argue.
Please make submissions on that.
On that also. Now, as we have seen, the first hearing is either for the settlement of issues. Here, my lord, there is no settlement of issues. Or for final hearing. Then, my lord, what is the distinction? It is only for the settlement of issues.
What is the final hearing, Mr. Rai?
Argument. Commencement of trial. If your lordship in that way also consider, what is the date for commencement of trial? Under Order 6 Rule 17. If the hearing took place and the trial commenced from the date of framing of issues, or from the date of when the court applied its mind. Commencement of trial.
Is the expression trial and hearing synonymous?
Yes, stand on
synonymous.
No.
Or
stand on different footings.
Yes.
Hearing. So, that is why I am submitting.
What is the starting date of hearing? What is the end date of hearing?
Starting the argument.
Hearing.
Yes. The starting date of hearing of a case starts from a subject to question, my lord, from the date of after closure of ওখানে argumented ইয়াজকে আগে argument করব এটা দেখ লেখা আছে after closing of the evidence when it is posted for argument,
then it is hearing.
Then the final hearing.
Authority for that.
I'll try.
No, because Mr. Rai, it uses the expression Order 9 Rule 61A. Hearing. If your submission is to be accepted, then after that, all proceedings will go, evidence will be concluded, then a date for argument will be fixed, then hearing starts. So, Order 9 Rule 7 will be only for that, only to participate in the hearing.
Well, Lordship, kindly see Order 20 Rule 1. Language is clear.
Order 20 Rule 1.
Before pronouncement of judgment.
Yes.
I have dealt with all those issues in my life.
তাহলে আবার জিজ্ঞেস করছি before pronouncement of the judgment, then my lord Kalikant, that is why I am submitting.
On which date, at which time, hearing concludes, I have dealt with that.
তাহলে আবার জিজ্ঞেস করা কি আছে
No. Now, since both of you are arguing, re-arguing, I am on an open mind. Please make your submissions on that. That is why I am asking you to clarify my points.
Yes.
That is why, since you have said that after that only the hearing, that is why I asked you.
Judgment after closing our argument of side. I'll give one. And can you consider order 18?
Yes.
Hearing of suits and examination of witness.
So it starts from the filing of the affidavit in chief.
Yes.
Yes, and Lord Lordship, can you see order 18 rule 19 is recording of evidence on commission. That
Yes.
Lord, that stage is also over.
Yes, so according to you, hearing stage is over.
Hearing stage over. Thereafter, Lordship, can you see order 19 is for Lord affidavit?
That is why. Why
Then
hearing and final hearing? Why hearing and final hearing? What is the meaning of final hearing?
Then Lord order 20 rule 1.
Yes, so where is the provision for arguments after closure of evidence?
Yes.
Thereafter judgment, order 20. Show me which provision says
Lord,
with regard to the
this provision is Lord, although Lord, there is a new amendment in CPC, Lord, this provision is different from Commercial Codes Act. So Lord, if we just look into the Commercial Codes Act, Lord,
Yes, yes. Let us kindly come to the Commercial Codes Act.
Lord, in the CPC, Lord, the normal closure is oral argument, then
Show me the provision for oral argument.
oral and written argument.
Yes, show me.
Here, Lord, commercial
Show me
code,
the provision for oral argument and written argument. Because according to you, once the commissioner submitted the report, hearing concludes. So thereafter, you cannot make any submissions also. Next stage is judgment.
Then
That's
if
your
that be so,
submission. Thereafter, order 19, adjournment, thereafter judgment.
Hearing.
Show me the provision.
Lordship, can you see?
Order rule 1. If my lords, I take advantage of my land right to begin.
Order 18?
Rule 1. Rule 1.
This stage is over.
Please tell me which stage is left. Show me from the provisions of the statute, which stage is left.
I'll just show me from.
And what is that stage?
Well, Lordship, kindly see the schedule of the Commercial Codes Act.
Yes.
The argument is নতুন amendment কত হলো CPC এর amendment
ওই আর্গুমেন্ট
আগের দিন দেখলাম
ওই যে ইয়ে ওই ইয়েতে আছে না না না
এটা বলো শিডিউল থেকে বাদ করে নেবে
আমার ব্রিফটা কই
লেখা ছিল
আমার ব্রিফটা কোথায় থাকে পড়তে বলতে ভালো লাগে filing of also argument commercial court sector.
Yes, my lord, Lordship kindly sees my lord schedule 18. TA. A party shall within 4 weeks prior to commencing the oral arguments.
Chakravarti, prior to that,
yes,
please kindly come to order 18, rule 2.
2.1. On the day fixed for the hearing of the suit or any other day to which the hearing is adjourned, the party having the right to begin shall state his case and produce his evidence in support of the issues which he is bound to prove.
So this is evidence part over?
This part over. Then Miller 3A.
Yes. No. Please kindly come to sub-rule 2.
On the day fixed for hearing of the suit or any other day to which the hearing is adjourned, the party having the right to begin shall state his case. Here Miller 18.1 Miller it takes care of and produce his evidence in support of these issues which he is bound to prove. Miller, I have Miller adduced evidence and cross-examination is over. So Miller up to Miller normal civil procedure code order 18 rule 19 Miller over. Through commission.
So according to you, So up to order 18, rule 2, sub rule 2, that is over.
That is over.
Thereafter, no stage.
Thereafter,
come
my
to
lord,
3A.
3A.
Yes, place
If-
3A.
Yes, a party shall, within 4 weeks prior to commencing the oral arguments, submit. So, my lord, in between only oral argument should be commenced.
So that is also a stage of hearing.
No,
Or
my lord,
that's not a stage of hearing.
my humble submission is, my lord, the hearing of the suit is specifically mentioned in 2. This is argument. My lord, statute is, my lord, the
Argument is not hearing.
My lord, argument, my lord, there is a bifurcation. If your lordship kindly comes, my lord, I'll just show it to your
Do
lordship.
you have any authority to cite in this regard?
Argument and hearing.
Argument is not hearing. Supreme Court judgment. Don't cite anything below that.
My lord, I tried a lot, my lord, I couldn't find.
Yes, there are Supreme Court judgments. I have considered that also.
My lord, argument is a hearing.
Yes.
My lord, then, my lord, I rest it, my lord, to your lordship. My lord, lordship kindly see. My lord, in case, my lord, I'm taking it, my lord, that
I have
argument is hearing.
Extensively dealt with these stages.
My lord, then, my lord, then also.
Each stage, order 9, rule 7 can be applied.
My lord, I'm grateful, my lord. Lordship kindly see, my lord, even that we saw. My lord, he
Wanted a rehearing, I have given you.
he has only the right, my lord, to start from that stage.
Only because I could have read out the judgment, but you have, since you have cited 2 decisions, I have to consider that. Otherwise, all answers are there.
In case a party, my lord, doesn't want to, my lord, proceed on argument, what would happen, my lord, in that case? My suit will be rejected, my lord. I may ask this question to myself. I have submitted, my lord, written notes of argument. As per the Commercial Courts Act, my lord, 4 weeks prior to that, or 3 months, whatever, my lord, I have filed. Now, my lord, I failed to
put to you, I will give that answer in my judgment. That answer I will give in my judgment. Anything more?
My lord, so far as his argument, my lord, the court fees point is concerned, my lord, we filed way back in, my lord, 2022. Now, my lord, even that be so, my lord, taking the best case that, my lord, the counterclaim was not registered before, my lord, filing the deficit court fee. My lord, then, my lord, this argument, my lord, makes the written statement, my lord, have no effect. My lord, then what would happen? My lord, there is no written statement. Then the court, in that case also, court has power to proceed under order written.
Provide the service of summons. I'm
Which
grateful
court
to
has
my
done.
landlord.
You have
There's
only,
service of summons.
you have only gone up to 1955. You have not considered any judgments after 1976 amendment.
76 amendment, my lord, service of summons is required. But, my lord, the problem is, my lord, they have filed, my lord, written statement.
I'm not opening my mouth now. Anything more? Mr. Chakravarti, if you want to file written notes, you are permitted to do so. Please do.
My lord, I'll file written notes, my lord. Then.
How soon can you file?
Kindly grant me this week time, my lord, I'll.
Please do it by Friday.
My lord,
Mr. Rai. Friday. Thursday will be the Friday. Thursday will be the. Mr. Chakravarti, you have made your arguments.
my lord, I need not.
Do it by tomorrow. Short these points will not be an elaborate. Do it by tomorrow. Mr. Rai.
Bullet points. Bullet points.
Yes, give mention only those points.
Hey, don't need a phone. Amar.
Today, when this matter is a great research work on this.
Judgment.
হ্যাঁ সিএবি করে দিন আর রাখবেন না
Before rising, my lord, Mr. Dotto is here, my lord.
Yes.
Mr. Dotto is here, my lord.
On Friday.
My lord,
Mr. Dotto will not demolish up to Friday. That will be like.
no, Mr. Dotto, my lord, has fairly, my lord, told me that.
Yes, which item?
My lord, 82. 82.
You have taken a resolution, Mr. Chatterjee.
No, my lord
You are
doesn't
moving this
record
back.
time in order. My lord doesn't record time in order.
What? You are violating your association's resolution.
No, my lord has expressed my lord's mind, my lord, only that Mr. Dotto, my lord required Mr. Dotto to be present.
You could not bring him prior to 3:30. Din 5:30.
My lord, very shortly, my lord was of the view, my lord, if the authorities do not take any steps, let that be clarified. My lord, then, my lord, the injunction, my lord, which I pray for, my lord, here, which was already granted by my lord's previous order, which at page 42, my lord, till 13th of July, and the learned 30th of June, and the learned trial court, my lord, was of the view since the interim order was passed by my lord, hence, my lord, the trial court would not.
The order of the trial judge.
My lord, trial judge, my lord, has passed no order, but
sorry.
my lord's order. My lord's order. Page 42.
Yes, yes, Mr. Dotto.
Well, your lordship kindly pass order, but I could not find that the trial court says that I cannot pass any interim order.
No, it has, my lord, my put up petition and my extension application has been placed.
From the order annexed, my
lord, this is, my lord, submission which fell from the learned trial
your
court. Observation.
Your lordship can extend. That your lordship can direct the trial court, my lord, this application.
So, Mr. Dotto, I am doing one thing without going into that controversy because since the earlier order, I think
my lord,
that was
page 42, my lord, 16th of May.
Your lordship can
this
extend.
matter, no order has been passed.
Oh.
And your lordship can direct
Previous
the
revisional
trial court to
application.
dispose of this
But
application.
Mr. Chatterjee, only difficulty is that the complainant is not here.
My lord, the answering respondent is the municipality.
No,
My lord,
the
they
other
are
respondent.
Complainant, on the basis of that complaint,
Right.
this order was passed.
My lord, this will, my lord, they are not objecting to that interim order which has been passed. My lord, what the learned trial judge did is, well, my extension application has been kept to date. My lord, an observation fell from the court, my lord, as told by my counterpart, that as my lord has passed an interim order, my lord, in High Court, so my lord, trial court would not transgress its jurisdiction, my lord, in extending the same till the next date of hearing fixed by the learned trial court.
But there is no such observation by the trial
No,
court.
my lord, it's fail observation. I'm not saying it's an observation.
Only difficulty, otherwise, in service, the matter will be kept pending. Otherwise, or I could have directed the appeal to be disposed of till that time stay.
Right.
But the only difficulty is that the complainant is not before the court. That's the
I understood.
Lord,
now.
I can bring the complaint by making service, but till that time, protect me. Well, my lord asked me, Mr. Dotto, to bring me, lord. He is fair enough to come here.
What is the violation, Mr. Chatterjee?
My lord,
You have
deemed
to put
sanction.
up the plan.
There are
Deemed sanction.
there are so many.
Show me the deemed sanction.
Deemed sanction cannot be shown by law. My lord, boita niya?
208.
208 provision.
Yes.
And my lord, my appeal
What is
to
the
the authority.
provision? Mr.
208.
Laughing from there.
208.
Yes, yes. What
Of
is
the
the
Bengal.
provision? What does
But
the
it
provision
says
say?
that if within the statutory period my plan which I have submitted is not granted or refused, my lord, and
then what steps you have
then,
to
my lord,
take?
an appeal is required to be preferred before
Show
the
me the
municipality.
appeal.
Yes, my lord. My lord, an appeal, my lord, on the last occasion, if earlier civil divisional,
Not satisfied.
my lord, on the same coin, my lord, on the last divisional application, my lord posed that question. I've shown an appeal to the authority. My lord's view was, my lord, it was addressed to, my lord, to the administrator, Panihati municipality. My lord said not administrator, but it has to be directly to the Panihati municipality.
Has to be.
Now, my
This is
lord,
an appeal because who can grant sanction?
my lord, the sanctioning authority is the chairman. My lord,
So
superior
it has
authority
to,
is.
yes, has to be a superior.
Now, my lord, superior authority at time board was not
Board
there.
of Councillor.
Board of councillor was not there. So, my lord, administrator was of the overall of the entire scenario. So, my lord, it was addressed to the administrator. So, my lord, it is the only appellate authority at that point of time when there was no board of councillors. So, my lord, I addressed the letter to the administrator
my lord, in that vacuum period. So my lord, administrator received my appeal, my lord, and kept it pending for that remaining statutory period.
Municipal authority, after hearing last recent order, that order has been challenged by them. They have appealed.
According to them, it's a deemed sanction. What can be done? You are sitting tight over the plan which they are submitting. You are not taking steps.
That will decide in the appeal. They have preferred appeal. And you also can direct the, my lord, appellate court, my lord, to decide the entire appeal within certain time.
Could have done so, and I could have said that till that time, but the other side is not
Other
here.
side not yet.
But a private respondent, I cannot find in court. I have to serve and then come back.
Mr. Chatterjee, or else I can do one thing. I can give you liberty to move the stay application there.
No, my lord, stay application has been heard along with the appeal itself. After hearing the respondent, my lord, the previous orders they looked into, the court records
No,
that
8th
after
of July stay application is being fixed.
yes,
Along with the hearing of the main
main appeal, yes.
So I
So,
will
my lord,
give
their
liberty
argument is left.
Till 8, they will not take any
Yes,
step.
yes, but my
On
lord,
8,
my lord, if they do not, because my argument is over. It's on their argument, it has been deferred. That is also recorded. Now, my lord, we have argued on the last occasion. Now, my lord, if they do not act,
only difficulty is that the other side is not here. That's the only difficulty.
my lord can extend it till 8 and kindly records that the trial court now hence will extend if it feels so. So otherwise, again, my lord, a revisional application will come up.
This application under Article 227 of the Constitution of India is at the instance of the
My lord only, my lord, I have mentioned one contempt application for inclusion in the list today. My lord, inadvertently, my lord, the writ petition number has not been indicated. My lord, kindly grants me leave.